Good morning, ladies and gentlemen. Welcome to the Hong Kong Legal Week 2025, a symposium of the HCCH Regional Office for Asia and the Pacific on private international law, and this will commence shortly. Everyone, please be seated and switch your devices to silent mode. 各位嘉賓，歡迎參與香港法律週2025海牙國際司法會議亞太區域辦事處國際司法研討會即將開始。請各位就座並將所有嘅裝置調到靜音模式。Please note that the symposium today will be conducted in English. Simultaneous interpretation is available in Putonghua and Cantonese. For on-site participants, you may collect your headsets at the entrance at the help desk. Online participants, you can select your preferred language channel on the Hong Kong Legal Week website. It is recommended to use headphones for a better sound experience. Please note. 今日嘅研討會將以英語進行，並提供普通話同埋粵語嘅即時傳譯服務。如果大家需要耳機，請到入口嘅服務台領取。線上嘅參與者可以喺頁面上面選擇呢個語言嘅頻道。咁當然啦，我哋亦都係建議大家使用耳機，因為咁樣嘅收聽效果會更加好。For participants who would like to apply for the CPD points or the ALE points, please sign in and sign out at the reception counter. Thank you very much for your cooperation. Not only that, please be reminded only in-person participants will be eligible for CPD points and ALE points. Please note you will find the QR code to access today's program on the screen and also on your table card. Thank you very much for your attention. Good morning, distinguished guests. Ladies and gentlemen, good morning. Welcome to the Hong Kong Legal Week 2025 and a symposium of the HCCH Regional Office for Asia and the Pacific on Private International Law, Transnational, Litigation, and Apostille, Innovating Practices under the HCCH Conventions. This is co-organized by the Hague Conference on Private International Law, HCCH, and the Hong Kong International Tenants Training Academy. Let me say that again, in the Hong Kong International Legal Tenants Training Academy and the Department of Justice of the Hong Kong Special Administrative Region of the People's Republic of China. Before we begin today's symposium, we would like to invite everyone to join us in observing a moment of silence. Last week, a devastating fire in Tai Po claimed many lives and left many injured. Let us take a moment to remember those who lost their lives, those that are still recovering, those missing, and all the families and individuals that are affected by this tragedy. In order to maintain a solemn atmosphere to show our respect to them, everyone please refrain from giving applause or giving claps during the symposium today. Everyone please make note. May I now also invite everyone to please stand up and observe 1 minute of silence. Thank you, everyone. Please be seated. Now, may we invite the Honorable Mr. Paul Lam Ting Kwok, GBS SCJP, Secretary for Justice of the Hong Kong Special Administrative Region of the People's Republic of China, to come on stage to deliver the welcome remarks. Mr. Lam, please.
Dr. Christopher Bernasconi, Consul General, distinguished guests, ladies and gentlemen. I'm honored to join you all today at the Symposium of the HCCH Regional Office for Asia and the Pacific on Private International Law, co-organized by the Hague Conference on Private International Law and the Hong Kong International Legal Talents Training Academy of my department as part of the Hong Kong Legal Week 2025. In fact, this is the first time that we co-organize an event with HCCH during the Hong Kong Legal Week. HCCH is our long-standing partner, and we have worked very closely with HCCH for decades. With the staunch support of the Central People's Government, the Hong Kong SAR has been actively participating in the working groups, meetings, and activities of the HCCH as part of the Chinese delegation since 1997. Through a standing arrangement with HCCH, Hong Kong legal talents from both the private and public sector have the opportunity to be seconded to the Permanent Bureau of HCCH at Hague, obtaining valuable insights into the work of HCCH in the field of private international law. In 2012, the Regional Office for Asia and Pacific of HCCH was set up in Hong Kong. Since its establishment, the Regional Office has played a significant role in increasing awareness and understanding of the importance of HCCH and its instrument among states and stakeholders, as well as contributing to the smooth implementation and operation of HCCH instrument in the Asia-Pacific region. Today's symposium is another example of our long-standing collaboration with HCCH. We are joined here today by esteemed speakers from different parts of the Asia-Pacific region who will share their insightful views on topics relevant to the theme of today's symposium, namely transnational litigation and Apostille, innovating practices under the HCCH conventions. Hong Kong has long valued the work of HCCH. A total of 9 HCCH instruments are currently applicable to Hong Kong, including the Apostille, Service, and Evidence Conventions, which will be discussed in today's symposium. Back in 1965, the first HCCH convention which applied to Hong Kong was the Apostille Convention, which is now one of the most widely applied multilateral treaties in the area of legal cooperation, with over 125 contracting parties, followed by the Service Convention in 1970 and the Evidence Convention in 1978. Under the principle of one country, two system, these HCCH conventions continue to apply to Hong Kong SAR since 1997. As the timing would suggest, these HCCH conventions were concluded at times which were vastly different from today. To adapt to the rapid and ever-evolving technological advancements over the years, HCCH has developed various new innovating practices to facilitate and streamline the functioning of HCCH convention in this digital age. These innovating practices include the Electronic Apostille Program, in short the EAP, which is aimed at supporting the electronic issuance and verification of apostilles around the world. The Hong Kong SAR has also implemented the EAP in recent years, which will be discussed by Registrar Kwan from the High Court of the Hong Kong SAR during the first panel discussion later today. With respect to the use of digital means under the other HCCH convention, taking of evidence by video link has been implemented in Hong Kong SAR for some years. In fact, video conferencing facilities have been used for remote hearings for suitable civil cases of the High Court since the 3rd of April 2020. I will leave further discussions to our experts at a second panel who will share their insights on how digital means could further enhance efficiency in litigation support under various HCCH conventions. Ladies and gentlemen, today's theme is timely as we explore how innovating practices, including digital means, can streamline cross-border document circulation and enhance efficiency in litigation support in the context of HCCH conventions. I hope today's symposium will allow us all to engage in meaningful exchanges and drive forward the future of private international law. Thank you very much.
And thank you, Mr. Lam. Please be seated. Thank you for the remarks. Next up, can we please invite Mr. Christophe Berlusconi, Secretary General of the HCCH, to board the stage to give us the welcome remarks. Dr. Berlusconi. Thank you.
Honorable Secretary for Justice Lam, distinguished guests, ladies and gentlemen. It is an honor and a pleasure to welcome you all to this symposium of our regional office here in Hong Kong during Legal Week 2025. On behalf of the Hague Conference on Private International Law, or the HCCH as we like to call it these days, I extend our heartfelt appreciation to the government of the Hong Kong Special Administrative Region, the Department of Justice, and the Hong Kong International Legal Talents Training Academy for co-convening this event. I have lost count of how many times I have had the pleasure to visit Hong Kong since I began working at the HCCH. Seldom, however, have I come under such sad and sober circumstances. The tragic fire in Tai Po has deeply affected this city, and our thoughts are with the families and communities who have suffered such loss. At times like these, we are reminded of how precious life is and how essential solidarity remains, not only in moments of tragedy, but also in the work we do together to build cooperation and trust across borders. Despite these sad circumstances, I extend a warm welcome to all distinguished judges, lawyers, academics, and officials from across the Asia-Pacific region and beyond, as well as colleagues joining us online. Your presence reflects our shared commitment to strengthening international legal cooperation and advancing the rule of law in the Asia-Pacific region and beyond. Hong Kong indeed plays a unique role as a bridge between the Chinese mainland, the Asia-Pacific region, and the wider world. This is precisely why, back in 2012, we established our regional office for Asia and the Pacific here in vibrant Hong Kong. I wish to renew my thanks to the central government, the Department of Justice of Hong Kong SAR, and the Secretary for Justice in particular, for the crucial and invaluable support over all these years that has enabled the regional office, ROAP as we call it, to operate effectively. ROAP has greatly increased the visibility of HCCH's work across the region. It has also helped attract new members and new states parties to our conventions, including those at the heart of today's discussions, the Apostille, Service, and Evidence Conventions. I'm confident it will continue to do so, especially when it comes to using innovative practices in operating these conventions, which is the theme of our session here today. We look forward to fruitful discussions and collaboration as we explore the digital future of some of our core HCCH conventions and their role in promoting legal integration across the region. Thank you.
Thank you, Dr. Berlusconi. And please be seated. Now, before we begin our day, we will start with our group photo. Let us first invite our co-organizers, our moderators, as well as our speakers on stage for this group photo. For this, can I please invite the Secretary for Justice of the Hong Kong Special Administrative Region, Mr. Paul Lam. Please join us on stage. Thank you. Secretary General of the HCCH, Dr. Christophe Berlusconi. Thank you. Dr. James Dane, please join us. Professor Zhao Yun, please. Thank you. Mr. Tian Zhenfeng. Dr. Yang Ling. Mr. Simon Kwang Chet Hong, please join us. Thank you. Professor Gyu-ho Lee. Mr. Ang Soon Lau, please join us. Welcome. Professor Afifa Kusumadora, thank you very much. Please join us. Attorney Janice C. Sanchez Rivera. Thank you. Last but not least, Professor Tu Guangjian, please. Thank you to everyone on stage. Please follow the instructions from our photographers for our group photo. Just a small step towards me, everybody. Thank you. Perfect. Just making sure we have all the pictures and videos. Thank you. Thank you very much, everyone. To all of our distinguished guests, please be seated. Thank you again. Appreciate it. Today, we have representatives and experts from various jurisdictions and international organizations to look at the innovating practices under the 3 HCCH conventions, namely the Apostille Convention, the Service Convention, and also the Evidence Convention, which are applicable to Hong Kong as well as many other jurisdictions. Now, there will be 2 sessions where the panelists will come on stage and they will share the experiences of implementing the conventions in the digital age, including some of the challenges that are faced and the recommendations on the way forward. Now, before our panel discussions, I would gently remind everyone to do 2 things. One is to double check on your electronic devices and please make sure that they are on silent mode or at least on vibrate. Thank you very much. This will maintain the silence and the atmosphere for our meeting today. And not only that, also another gentle reminder is that to remain a solemn atmosphere, everyone please refrain from giving applause or giving any hand claps during our segment today. And again, I just want to express my gratitude to everybody that is with us in person today and everyone that is watching from your home and your office. Thank you very much for being with us. Right, as we are setting our stage for our panel discussion, everyone please invite with me, without clapping, the Secretary General of the HCCH, Dr. Christophe Berlusconi, and he will come on stage and he will give his keynote speech to us. Thank you. Awaiting, yes. Thank you.
Secretary Lamb, ladies and gentlemen, we stand at a pivotal moment in private international law. The digital age is not only reshaping traditional private international law techniques, often based on physical connections, it is also transforming cross-border legal cooperation under HCCH conventions. And so the purpose, the objective of this keynote is essentially to set the stage of what is about to follow, an in-depth discussion on how the digital age is impacting the operating and changing, developing the operation of the Apostille, Service and Evidence Conventions. One of our flagship conventions, particularly in the field of legal cooperation, is indeed the 1961 Apostille Convention. With 128 contracting parties, it represents the largest share of the 1,041 ratifications and accessions to HCCH conventions in total. It streamlines the circulation of public documents abroad by replacing cumbersome legalization with a single formality, the issuance of an apostille certifying the underlying public document's authenticity, or origin, if you want. While an apostille produces exactly the same effect as the legalization chain, the process is much simpler and far more efficient. It saves time, money, and resources for both the applicants and consular officials. With millions and millions of apostilles issued around the world every year, the Apostille Conventions is also the most frequently used HCCH convention. In 2021, based on statistical data available at the time, it was estimated that approximately 35 million apostilles were issued globally each year. In August of the same year, an independent expert study further indicated that the convention generated an economic benefit exceeding €500 million per year for all contracting parties combined, primarily through savings in time and administrative resources. It should be noted, and this is important, that these estimations predate the accession of several states, including China for its mainland. It is therefore reasonable to believe that these figures have increased substantially since 2021. The Apostille Convention's importance has also been acknowledged by key international stakeholders. Notably, the convention is referenced in the methodology underlying the World Bank's Business Ready or Be Ready report, which was released in October 2024. This methodology is used by the World Bank to assess economies across the world. Being party to the Apostille Convention thus enhances a state's attractiveness for cross-border trade and business. Today's first panel will discuss how the operation of the Apostille Convention has greatly benefited from new technologies. In this regard, the Electronic Apostille Program, the EAPP as we call it, has been a key development. The EAPP takes the Apostille Convention into modern times. Remember, the convention dates from 1961, at the time when the Kodak carousel slide projector had not even been introduced. I hope some of you still remember what the Kodak slide projector is. This big machine, very noisy, very, generating a lot of heat that could show slides. So that even was not invented or presented when the Apostille Convention was introduced. The internet, well, clearly, it did not exist either. Launched in 2006, the EAPP has two components: the e-apostille, electronic or digital apostilles, and the e-register, an online register that can be used by a party who has received an apostille to verify the origin of that apostille, be it a papal or an e-apostille. The EAPP enhances the secure and effective operation of the Convention and offers a powerful and effective deterrent to fraud. In practical terms, the EAPP improves the process of requesting an apostille, the issuance of an apostille, presenting an apostille in another contracting party, and finally, where necessary, its verification. As of November 2025, 59 out of 128 contracting parties have chosen to implement one or both components of the EAPP. Many of these contracting parties are in the Asia-Pacific region, demonstrating the region's progress in embracing innovation. So the EAPP really is a prime example of how HCCH conventions, which do not refer to specific technology, can adjust to changing times and developing technologies. Based on functional equivalence and technological neutrality, these are key ingredients for adaptability of conventions over time. Two other important HCCH conventions that will be discussed today are the 1965 Service Convention and the 1970 Evidence Convention. They are also among the most widely used HCCH conventions in practice and prime examples of effective, practical multilateralism. Like other HCCH conventions, the Service and Evidence Conventions do not aim to alter or affect the national laws of contracting parties, in particular no impact on procedural laws. Instead, they build bridges between different legal traditions by establishing simple, clear, and effective mechanisms or frameworks under which contracting parties can cooperate. These conventions aim to improve procedural efficiency. The Service Convention simplifies the process of transmitting judicial and extrajudicial documents abroad. It was, in fact, the first HCCH convention to implement the system of central authorities, which, of course, has since then been successfully replicated in various other HCCH conventions, including the Evidence Convention, which streamlines the process of requesting the taking of evidence abroad in civil or commercial matters. Clearly, by assisting parties, litigants, and their representatives, these conventions increase certainty and predictability and enhance access to justice. Collectively, these conventions have created a predictable, efficient, and secure legal environment for international civil litigation, greatly facilitating economic growth and trade, as well as the mobility of people, goods, and services within the Asia-Pacific region and beyond. We note, however, that there remains significant potential for broader adoption of these conventions in the Asia-Pacific region. For example, currently, only about half of the jurisdictions in the region are parties to the Service Convention. This reality underscores the urgency of strengthening capacity building and promoting knowledge sharing to assist more economies, particularly developing ones, in bridging procedural and digital divides and fully leveraging the benefits offered by the conventions. Information technology has also become an essential tool for the effective operation of these conventions, Service and Evidence Conventions. For example, there have been many important developments with regard to the electronic transmission of requests, including via email or decentralized platforms. Likewise, more contracting parties have reported the possibility of serving documents electronically, e-service. Under the Evidence Convention, it is becoming increasingly common to use video links to participate in hearings or even to directly take depositions from witnesses located abroad. Electronic communication between central authorities and other authorities designated under the conventions is increasingly becoming the norm. But again, more can and should be done to expedite processes with the help of technology. That being said, the use of information technology also poses some challenges. Not all contracting parties have the same technological infrastructure, and the ability to use information technology varies among states, including under domestic laws. Some parties have raised concerns about IT use, including transmission security and data protection. The Permanent Bureau has been following all these developments with great interest. While monitoring the operation of these conventions, the PB has supported a number of meetings specifically aimed at discussing the use of IT under HCCH conventions. In the context of the Apostille Convention, I should mention our International Forum on the EAPP, a highly successful event that generally takes place every 2 years or so and brings together a large number of contracting parties to discuss the EAPP and share their experiences with its implementation and operation. The next edition of the EAPP Forum is envisaged to be held in May 2026. Stay tuned for more information. Regarding the Service and Evidence Conventions, an in-depth discussions on IT was held at the 2024 Special Commission meeting. Following that meeting, CGAP is our governing body of the HCCH, mandated the PB to convene meetings of central authorities to exchange experiences and develop a deeper understanding of the use of information technology, as well as to provide additional guidance on the e-transmission of requests and related matters. The first online meeting is scheduled to take place in the first half of 2026. The PB has also undertaken several initiatives to support our members and contracting parties. For example, it is currently working with HCCH members to develop a set of good practices for central authorities and other designated authorities under the Service and Evidence Conventions. Many of these good practices are specifically tailored to the implementation and effective use of IT by authorities involved. The final document will be submitted for approval to our governing body in March 2026. Another important step has been the introduction of e-country profiles, online profiles that provide comprehensive information on the operation of the Service and Evidence Conventions in contracting parties, including the use of IT. Finally, and certainly not least, the use of IT has been extensively addressed in the second, that is the most recent edition of the Apostille Practical Handbook, as well as in the recent 5th editions of the Service and Evidence Practical Handbooks, the latter of which have recently been published and are available for purchase. I commend these handbooks to you. These handbooks are an essential resource for anyone involved in implementing and applying the Apostille Service and Evidence Conventions, and I highly encourage you to consult them. The Asia-Pacific region's depth and efficiency of legal cooperation are crucial to global economic growth. The economies in this region are highly diverse, encompassing both highly digitalized jurisdictions and legal systems that are still in the developmental stage. With the ongoing advancement of regional economic integration, the need for efficient and transparent cross-border dispute resolution has become increasingly urgent. The HCCH conventions and their digital compatibility offer the ideal solutions to meet this need. The key to moving forward lies in collaboration in the following areas: capacity building and knowledge sharing. The HCCH stands ready to collaborate with stakeholders to deliver more training sessions in the Asia-Pacific region. We will share best practices, such as the APP, to assist members in bridging the digital divide. Facilitating a regional dialogue. By leveraging platforms such as this symposium, we aim to encourage jurisdictions across the Asia-Pacific region to exchange experiences, build consensus on technical standards and operational guidelines, and progressively foster regional mutual trust. And finally, promoting pilot initiatives. We call upon and stand ready to support Asia-Pacific countries to launch pilot projects for secure digital procedures within the frameworks of the Service and Evidence Conventions, thereby generating valuable experience for the region and beyond. As mentioned, we stand at a crossroads in history. The spirit of international legal cooperation embodied in the HCCH conventions and the efficiency revolution brought about by the digital age are converging. The Asia-Pacific region is renowned for its vitality and innovative spirit, and I firmly believe that through continuous collaboration, whether between governments and international organizations, among various jurisdictions, or between the public and private sectors, the Asia-Pacific region is fully capable of becoming a leader in the digital implementation of the HCCH conventions and setting a remarkable example for global legal integration. So, when assessing possible synergies for Asia-Pacific legal integration, a clear and practical step forward would be, for example, for all ASEAN member states, and indeed all states participating in APEC, to join the Apostille, Service and Evidence Conventions, if not done already. These instruments are not only foundational to international legal cooperation, they embody well-established standards that have proven highly successful and adaptable to technological developments. By embracing these conventions, jurisdictions can greatly facilitate basic legal cooperation and strengthen regional integration without the need to reinvent the wheel while simultaneously building bridges to the rest of the world. It is quite simply a clear win for all involved. I'm sure the platform provided by this symposium will further explore opportunities for cooperation and regional integration. Let us work together to build a rule of law future empowered by digital technology and underpinned by these core HCCH conventions. I would like to thank again our partners, the Department of Justice and the Hong Kong International Legal Talents Training Academy, for being such a valuable partner by our side in doing so. I would also like to conclude by thanking Professor Zhao Yun and his team at our regional office for Asia and the Pacific for their tremendous efforts in preparation for this event. I would like to express my appreciation to all the speakers participating in the symposium, and we look forward to your valuable insights. I wish this symposium every success. Thank you all.
Thank you, Dr. Berlusconi. Thank you for that, and please be seated. For our first session, we will explore how the Apostille Convention is streamlining cross-border document circulation, including through digital means, e-Apostille. Can we now please invite our moderator of this panel, Dr. James Deng, the Law Officer, International Law, Department of Justice, Hong Kong Special Administrative Region, to board the stage. Thank you. And also our panelists, Mr. Tian Zhenfeng, please join us. Mr. Simon Kwong-Chat Wong, please. Attorney Janice Sanchez Rivera, with pleasure. And also Mr. Ang San Lao, please, board the stage. Thank you. Everyone, please make yourself comfortable. Please note there will be a Q&A at the end of the discussion. Therefore, please scan the on-screen QR code to submit your questions. I will now pass the floor to Mr. Deng. Thank you.
Thank you for joining the symposium today. And we are starting our first sessions. And as our Secretary has just mentioned, the Apostille Convention is the most popular Hague conventions ever, with over 120 contracting parties. At these sessions, we'll be looking at the Apostille conventions, and more from the technology perspective. We will also mention the practice of EAPP. We will hear our distinguished speakers so that we know the practice in different jurisdictions. And we also have a very good panel of distinguished speakers from jurisdictions in these regions. We have Mr. Tin Zhenfeng from representing China. Mr. Li Yong is unable to come for some unforeseen reasons. We have invited Mr. Tin Zhenfeng, who is the Deputy Director General of the Office of the Commissioner of the Ministry of Foreign Affairs in the Hong Kong SAR. So we will have him speaking from the perspective of China. We will also have a speaker, a local speaker from Hong Kong, Registrar Mr. Simon Kwang. He will tell us about some recent developments about the Apostille in Hong Kong. And we also have speakers from the Philippines and Singapore. We have attorney Ms. Janice Sanchez Rivera from the Philippines and Mr. Eng Xiong Liu from Singapore. We will hear from them about the practice in the Philippines and Singapore as well. And given that we have run out a bit of time, so I have to ask our speakers to be very strict on the time so that each speaker should speak no more than 15 minutes. Yeah. So without further ado, I will now invite Mr. Tin to give us presentations. And he will be speaking in Chinese. So for those who need, you may use the headphone for the SI translations. Yeah. Mr. Tin, please.
Yes, I'm sorry for the inconvenience. Your Excellency Secretary General Berlusconi, distinguished Your Excellency Mr. Lan, distinguished guests, ladies and gentlemen, good morning. Thank you very much once again to the organizers for the thoughtful arrangements for the seminar. I would like to take this opportunity to share with you China's experience in implementing the convention, abolishing the requirements of the legislation for foreign public documents, the convention, and I look forward to exchange my ideas with you. In today's world, the political, economic, and cultural exchanges and cooperation among different countries are deepening and weaving our world into a community with a shared future. So by facilitating the cross-border circulation of documents through the simplified one-step apostille procedure, the convention reduces or eliminates the institutional costs and barriers in international civil and commercial dealings, significantly enhancing the efficiency and international trade and people-to-people exchanges. Its vital role is increasingly widely recognized by the international community. This aligns with the principles of a common prosperity, openness, and inclusiveness by China. Openness is a defining feature of China's modernization. China adheres to the model of a high-standard opening up, takes the initiative to align with international rules, steadily expand in institutional open-ups, and integrates deeply into the global governance system.
In 2023, China formally acceded to the convention, joining the Apostille family. Over the past 2 years, China has issued nearly 3 million apostilles documents and presenting a new landscape for the circulation of a Chinese public document abroad. And it's more economical and more convenient. The average processing time for document circulation between China and other contracting parties has been reduced by 19%, saving Chinese and foreign countries and enterprises over 300 million RMB annually. The Convention's model of a one certification for universal recognition is more conducive to facilitating international civil and commercial activities. Following this, we have undertaken comprehensive and in-depth reforms of our domestic legal system with efficient and pragmatic actions to better align with international standards. Firstly, systematically revising domestic laws and regulations. We comprehensively reviewed the domestic laws and regulations related to the Convention and facilitating corresponding interpretations by legislative and judicial authorities, and clarify the legal effect and scope of an application of apostilles in China. Secondly, establishing an efficient issuance system. China is a vast country with large population and a tremendous volume of public documents. Therefore, in addition to the Ministry of Foreign Affairs, China has incorporated provincial and some municipal foreign affairs departments into this apostille issuance systems and build a unified national issuance management system. And this ensures the unified, standardized, and efficient operation of the system and allowing citizens and enterprises to enjoy the convenience. Thirdly, conducting extensive publicity on this convention and ensure the document usability, and through internal circulars, news media, professional training, and we have employed multiple channels to publicize the mechanism and increasing the awareness of this apostille system to ensure the benefits of the convention reach end users. And we also build this fully supports platform and provides user-friendly and reliable verification services for contracting parties. China's participation and implementation of the convention have fully drawn upon the advanced practices and the valuable experience. And we have received substantial support and assistance from HCCH, for which we express our sincere gratitude. Currently, a new wave of technology revolution and industrial transformation is deepening with frontier technologies such as blockchain and AI. And the legal framework in related areas have been strengthened and improved. For example, in recent years, we have seen the electronic signature law and the data security law. And on 18 June this year, China formally issued its first electronic apostille, making the entry of China's authentication system into a new digital era. And there are three focuses. Number one, digital security and temper resistance. China's apostilles merge the original public documents and the electronic apostille into a single electronic file. Technologies such as blockchain and electronic seals ensure the documents' immutability. Number two, compatibility between electronic and paper verification. And China's electronic apostilles contain an embedded verification link, allow authenticity's confirmation with a single click. Number three, balancing convenience and privacy protection. We implement the management of various types of private information contained with electronic apostilles and original public documents. And this effectively protects the privacy of people. Recently, the fourth plenary session of the 20th Central Committee of the Communist Party of China proposed the 15th five-year plan, and this calls for further comprehensively deepening reform and advancing the Digital China initiative. And as the digitalization of various public documents in China, we will continue to expand the scope of electronic apostille and providing higher quality and more efficient cross-border document circulation services for Chinese and foreign citizens and enterprises. China also has constantly paid attention to the challenges. For example, the verification needs for the apostilles by other countries, as well as inconsistencies in the types of public documents. In the face of the rapid development of information technology, China believes it is essential to continue upholding the Convention's purpose. And we should adapt to the trend of document digitalization and strengthen communication and mutual learning and then jointly foster this convention. And the parties can engage in beneficial discussions on continuous optimizing these apostilles. And we can provide more convenient and reliable verification services. China cannot develop in isolation from the world, and the world's prosperity also needs China. China is willing to engage in exchanges and discussions with all parties regarding this convention, and we also support the efforts to the permanent development of HCCH and China, and want to become the catalyst for breaking down the barriers in the digital age. Thank you very much.
Mr. Tin, Mr. Tin has just told us that while the Chinese mainland only applied the convention for about 2 years, but remarkable progress has been made. In particular, they have already implemented the e-apostilles in a very secure and convenient manner. And I also looked at it has saved over 300 million renminbi. And also the time reduced is 90%. So it's a remarkable progress. And it also shows how useful the Apostille Convention is. So I would urge those states which have not yet acceded to the Apostille Convention to actively consider acceding to this convention, given what Mr. Tin has just shared the experience of China in becoming a party to the conventions. Our next speaker is from Hong Kong, Mr. Simon Guan, Registrar of the High Court. He is responsible for issuing the apostilles, and we have recently implemented the e-apostille. So Registrar Guan will be introducing the recent developments in Hong Kong.
Dr. Pascani, distinguished speakers, experts, participants, and guests from all over the world. Good morning. It is my honor to be invited to speak in this year's Legal Week, while I was also invited to speak at the last year's Legal Week on different topics. This year, I shall talk on a topic of growing importance of our interconnected world, the e-apostilles. You remember that I talked also on the Apostille Conventions in 2023 in the HCCH Asia Pacific Week in celebrating its 130th anniversaries of HCCF. On that occasion, we have not yet implemented the e-apostilles. Today, I would like to update the positions. E-apostilles have two components, as already mentioned by Dr. Bassiconi, the e-apostilles and the e-register. E-registers have been implemented in the Hong Kong SAR since 2014, providing an online platform for public verifications of apostilles certificates issued by the High Court of Hong Kong. During the HCCH Asia Pacific Week Conference 2023, I have mentioned that the judiciaries of the Hong Kong SAR has conducted the feasibility studies on establishing an e-apostille system. These presentations are built on the previous one. I wish to update and report that starting from 1st September 2025, this year, the issuance of e-apostilles commenced in the Hong Kong SAR, providing a digital alternative to traditional paper-based process. Further details about the e-apostille system will be explained later in these presentations. Let's begin with an overview. Hong Kong became a member of the Hague Apostille Convention since 1965. The competent authorities under the Apostille Conventions are the Administrative Secretary, myself as the Registrar of the High Court, Senior Deputy Registrar, and Deputy Registrar. The Apostille Service applies not only to a broad range of public documents, such as birth certificate, marriage certificate, and business registration certificate, but also to documents signed by a notary public or a commission of oath in the Hong Kong SAR. This chart demonstrates a more than two-fold increase in the number of apostilles issued over the past 5 years. Between 2021 and 2024, the number grew by about 105%, more than doubles. In 2021, we issued issued about 81,000 apostilles, but in 2024, we had already issued 167,000 apostilles. Notably, the counts for 2025, counting from January to November, we have already surpassed the total of 2024, which means that the total of the apostilles which we shall issue in 2025 will reach another record high of likely the number of 200,000 for this year, which means that we issue and receive an application for apostille of 900 per day. So why we need e-apostilles? Previously, every apostilles application required a physical visit to the Apostille Service Office of the High Court. Applicants presented documents for manual checking and wait for collections, often facing queues. Such hurdles may seem exhausting, especially for cross-border professionals working under tight deadlines or remotely. As a major legal and financial hub, Hong Kong SAR faces growing international expectations for digital-first, remote-friendly solutions. E-apostille simplifies the process. Everything from submissions to collection can now be completed online, including e-payment of the fees. At the same time, this change does not affect the validity of an apostille. The core principles remain that an apostille is validly issued by any contracting accepted by all other contracting parties. For our version 1 e-apostilles, we try to aim an objective, simple and easy to use. I will explain the reason why. Of course, we will not forget the security issues. Issue of e-apostille simplifies the authentications and legalization process, reduce administrative work, and enhance securities and efficiency of the documents verifications. E-apostilles can be easily transmitted and verified online, facilitating faster and more convenient cross-border transactions. In fact, this change benefits all of us. Applicants at the present moment are mainly notary publics. There's no need for their physical presence. They can apply, pay, and collect the apostilles anytime online. Less time-consuming, of course. For the recipients, verification is faster and easier. Securities, modification for the apostilles documents is noticeable. For frontline staff of our office, a preliminary checking done automatically. The time for the document checking is shortened, less labor incentive in terms of application and payments. So for our implementation of e-apostille service, the initial phase of our e-apostilles was designed for notary publics. Why we choose it? Because according to our statistics, applications for our Hong Kong apostilles mainly come from notary publics. They account for over 50% to 60% of the numbers of applications for apostilles. Notary publics of Hong Kong, they come from senior members of the solicitors' professions. They need to have at least 10 years post-qualification experience and need to pass examinations of the notary societies. I was told the pass rate is very low. So that those who pass the exam and practice as a notary public in Hong Kong are respectable members of the professions. They would exercise due care in conducting their business. So currently, we have about 360 enrolled notary public in the Hong Kong SAR, and out of which 126 of the notary publics have now registered as our user of our e-apostilles. So they are active members of the notary societies who will seek apostilles from the High Court of Hong Kong. The response from the notaries community has been positive. To facilitate the implementation of the e-apostille service, a demonstration session was held in August 2025 for the Hong Kong Society of Notaries and the Department of Justice. 28 participants attended in person, while 183 joined the session online. Besides user guide, demonstrations, videos, and FAQs have been uploaded on the judiciary website. Technical helpline is also available to provide technical support. The applications for e-apostilles are quite encouraging, I must say, since we implemented only in September this year. Up to last week, we have received and I have issued 52 e-apostilles. While a few applications were refused owing to technical issues, others have been accepted and issued within less than 2 days. So that every afternoon, I will receive alert that I have an application for e-apostilles. My colleagues and I will process it on the same day. In the e-apostilles application process, the notary public will digitally sign the document in PDF format, submits the e-apostilles application online, makes payment electronically as well. The apostille service office then checked and processed the application. Once approved by myself and my colleagues, we will digitally sign on the system through a USB tokens, and the notary will receive a notification email, after which they can check the application result and download the e-apostilles documents electronically. I don't think I would go through the whole system requirement. These are all on our website. As I said, we aimed a simple and user-friendly system. We mainly ask the notaries to subscribe to the e-certificates, which are issued by the Hong Kong Post and also the DigiSign certificate service. The email address included in the digital certificate used for digitally signed documents has to be the same as the registered with the e-apostilles office, and the system is specifically designed to prevent unauthorized access. I don't repeat. Basically, our office, the staff of our office will check and will focus on the signature, seal, and the upload documents, and myself will approve and or reject the applications. There are multi-layer checkings to ensure accuracies and authenticities. The result, we will send out emails, as I said, and they will receive it afterwards. Our e-apostille certificate will include a cover sheet, an e-apostille certificate, and the original documents. These documents cannot be separate or modified. Otherwise, the e-apostille certificate becomes invalid. The e-apostille certificate is issued with the seal of the High Court. Both the apostille certificate issued manually and electronically would also bear an URL and a QR code for verification. This QR code is a new feature since I talked in 2023. The apostilles can be verified online under our established e-registered. Again, they need to check using the QR codes. I think I don't want to spend too much time on these technical matters, which I think for user, you can deal with it online and can check with our website. So these are the verification process. And we have about 8,000 verifications online last year, and up to now, up to November, we have 7,600. Way forward. While we implement our version 1, we will have to review and make enhancement. I don't know when, but of course, we will try to see whether we have version 1.1 or 1.5. And then we will hope to implement version 2 in near future. Looking ahead, Hong Kong SAR plans to extend the e-apostille service to cover other categories of public documents. At present, it's only notary certificate, notary documents. It would include documents issued by government officers whose specimen signatures and seal are already kept on the record at our office, such as companies' registration documents, birth or death certificate, marriage certificate. These gradual expansions will enable more government departments and members of the public to benefit from the efficiency and reliability of the e-apostilles framework. It is anticipated the numbers of apostilles issued will continue to grow and increase. Therefore, promoting the use of e-apostille service is essential to meet the growing demand. We have to regularly update and enhance our e-apostilles infrastructures to ensure it remains efficient, secure, and aligned with the latest technological standard. Before I conclude my speech, I know that I'm over time a little bit already. Please allow me to say a few words on the tragic fire happened last week at Taipo. Some of the victims are citizens or national of your countries. From the news reports, I'm saddened to learn that at least 9 Indonesian domestic helpers suffered fatal injuries and died, and another one sustained injuries. At the same time, one Filipino maid was killed and another was injured. While I would like to express my deepest condolences to the families of the victims, in order to expedite the processing of their application for probate or letter of administrations of our probate registry, which is I myself also assume as the registrar of the probate registry of the High Court of Hong Kong, I would urge Indonesia's and Philippines' competent authorities to expedite the issues of apostilles for various public documents which may assist our registry to process the application for probate or letter of administrations, such as birth certificates, marriage certificate, etc. I note that Philippines has already implemented e-apostilles already. We shall accept the e-apostilles documents for the purpose of processing any applications for probate or letter of administrations without the need of troublesome and time-consuming legalizations. I want to explain this is the advantage of our apostilles conventions. On these kind of, I might say, tragic events, that would speed up the whole process of any need for processing public documents for the purpose of helping the families of the victim to receive compensations in the near future. Thank you.
Thank you, Richard Shokwan. Thank you for highlighting the usefulness of the Apostille Conventions. It's not only relevant to commercial transactions, but also to other civil matters as well, including the, unfortunately, the tragedy that just happened last week. And Richard Shokwan has highlighted the advantages of the EAPP and the reasons why Hong Kong has implemented the e-apostilles, saving a lot of time and cost, including manpower. So it's a very useful system that Hong Kong has just implemented, and that provide very convincing reasons why contracting states should actively consider using the EAPP or implementing the e-apostille. Our next speaker is from the Philippines, Attorney Sanchez Rivera, and she is the acting director of the Authentications Divisions of the Office of Consular Affairs of the Department of Foreign Affairs of the Philippines. And she shared with us the experience of the Philippines. So the floor is yours.
Good morning, distinguished colleagues, partners, and fellow competent authorities. It is an honor to speak here at the Hong Kong Legal Week 2025 and to share the Philippines' experience in transitioning our authentication services from traditionally paper-heavy towards a digital, interoperable, and secure e-apostille system, making the Philippines the first in ASEAN and the third in the Asia-Pacific region to fully implement the electronic apostille. Let me briefly walk you through today's presentation. I will begin with a brief background on the Philippines' accession to the Apostille Convention. Next, I will walk through the paper apostille framework, how our current physical and online processes work. And finally, I will focus on our digital transformation initiatives, particularly the rollout of the Philippine e-apostille and our ongoing interagency work to enable wider integration. As a backgrounder on the Philippine accession to the Apostille Convention, the Philippines acceded to the Apostille Convention on September 12, 2018, and it entered into force in the Philippines on 14 May 2019. This marked a major milestone for the country because it simplified document legalization for millions of Filipinos, especially overseas workers, students, and entrepreneurs who rely heavily on authenticated public documents. Under Executive Order 582, Series of 2006, the Department of Foreign Affairs is mandated to be the sole agency responsible for authenticating public documents. This mandate extends naturally to the issuance of apostille. The DFA remains the sole competent authority in the Philippines. We operate through our main authentication division in DFA ASEANA and through our consular offices nationwide that provide apostille services. This map shows the consular offices that issue apostilles. Expanding access outside Metro Manila ensures that applicants across the country can avail of services without traveling long distances. The paper apostille issuance framework. Here, the slides show how our physical apostille has evolved between 2019 and 2025, including enhanced security stickers, improved layout, and integration of QR verification through our electronic registry. Our apostille contains the 10 standard informational items, including the country of origin, the public official's name and title, the serial number, and the signature of the authentication signing officer. We also include additional information, such as the document type and an e-registry key code to enhance transparency and verifiability. For the physical submission workflow, let me walk you through the workflow. The workflow follows clear stages: processing, encoding, signing, sorting, scanning, and releasing. Each stage has quality control measures to ensure accuracy and detect irregularities. For physical processing, applicants walk in and present the original documents. Trained processors check for security features and verify signatures against our specimen signature database. During encoding, personnel evaluate the document and input key details into the apostille issuance system, or the APIS. A signing officer conducts a third layer of review and affixes an electronic signature. If we encounter any discrepancy, like outdated signatures, missing specimen signatures, inconsistencies, or possible tampering, we coordinate with issuing agencies for verification. To support verification, we maintain a comprehensive internal specimen signature database, both in hard and soft copies. And we request updated specimen signature from agency every year. This database is strictly confidential and used only for authentication. After signing, apostilles are assembled with their attachments, including the grommet and hologram stickers. They are then scanned for internal storage and added security layer. And finally, the apostille is released to the applicants upon presenting the receipt and a valid ID, and this multi-layered process ensures both accuracy and protection against fraud. To make our services more accessible, we introduced an online workflow, starting with the Philippine Statistics Authority, or the Philippine National Civil Registry. The online ordering workflow streamlines the entire process for applicants. Using the Philippine Statistics Authority, or PSA, Civil Registry document as an example, applicants order a PSA certificate online and upload their identification. Payment for PSA, the Department of Foreign Affairs, and delivery services are consolidated into a single transaction. PSA then issues the certificate in security paper form, and the PSA certificate is delivered to the DFA, where the apostille is then processed, encoded, signed, and released to the courier for delivery to the applicant's address. For the applicants, this eliminates long lines and travel costs. For the government, it strengthens traceability and reduces opportunities for document manipulation. Now we move to the core of today's presentation, the transition from paper to digital. The shift from paper to digital began with the launch of the Philippine e-Apostille on 19 March 2024. Phase 1 focuses on PSA e-certificates for civil registry documents, and we are currently finalizing the integration with the Commission on Higher Education certificates for school documents. Since the launch, we have issued 34,473 e-Apostille, demonstrating strong adoption and operational readiness. The integrated workflow can now issue both paper and electronic apostilles. Again, using PSA civil registry documents as an example, applicants order a PSA certificate online. The application will undergo the same process. But for electronic apostille, PSA certificates go directly to the DFA e-Apostille system. An electronic apostille is generated and immediately becomes accessible through our e-registry. Applicants receive their certified documents via email. This enhances efficiency, reduces courier delays, and increases security because only original issuing agencies can transmit official documents to the DFA. This is a sample of the email received by the applicants. It contains the e-Apostille certificate along with an e-registry link for verification. This end-to-end digital pathway removes the need for physical visits and significantly reduces processing time. The PSA certificate has a QR code and the serial number of the apostille attached to it so it can easily be identified. The Philippine Apostille e-registry is a verification tool accessible online. It allows users to confirm the authenticity of any given apostille. It also compares the uploaded document with DFA's internal records to detect alterations or tampering. This feature strengthens the trustworthiness of our digital apostille. To support this transition, the DFA invested heavily in capacity building. Our personnel undergo certification programs on authentication and attend workshops on question document examination with the Philippine National Police Forensics Group and the National Bureau of Investigation of the Philippines to strengthen their skills in fraud detection and signature analysis. We also work closely with agencies that issue public documents, such as the Supreme Court, the Integrated Bar of the Philippines, and the National Bureau of Investigation to harmonize requirements, improve security features, and prepare for digital integration. Foreign delegations have visited the Philippines to understand how we implement the convention. These exchanges reflect the growing interest in digital apostillization and the value of shared experience. Two important institutional partnerships strengthened our e-Apostille project. First is the 2024 MOA with PSA, or the Philippine Statistics Authority, which enables secure digital transmission of e-certificates to the DFA. A 2025 MOA, or the with CHED, allows direct receipt of Commission on Higher Education certificate for apostillization. These partnerships ensure that the source documents themselves are secure and digitally verifiable, an essential foundation for a trustworthy e-Apostille. Later this year, the DFA will host a national workshop with government agencies to promote the issuance of secure electronic PDFs and facilitate their integration into our e-Apostille system. This is a crucial step in expanding e-Apostille coverage to other public documents, and this is a whole of government digitalization effort. In closing, the Philippines' transition from paper-based authentication to a secure digital Apostille framework reflects our commitment to modernizing public service, enhancing cross-border mobility, and strengthening trust in official documents. Our work continues, but the foundation has been built. Partnerships are strong, and our direction is clear: a fully digital, secure, and globally interoperable Apostille system. Thank you very much.
Thank you, Ms. Sanchez Rivera, and thank you for sharing the experience of the Philippines. And at the end of your presentation, you also highlighted the importance of training and capacity building, in particular for the use of e-Apostille. I think that's very useful, and I think it's also one of the objectives of the EAPP forum that the Secretary General just mentioned that will be held next year, so that it will provide another opportunity for more exchanges and learning the experience from each other. So maybe participants can also watch out for the EAPP forum and on the website of the HCCH and participate in the forum. Last but not least, we will hear the experience in Singapore, and we have Mr. Liu, who is a cluster director from the Enterprise Transformation and Innovative Group of the Infocom Media Development Authorities of Singapore. So the floor is yours, Mr. Liu.
Hi, thank you. A very good morning to all speakers and guests present at today's seminar. My name is Ing Soon, and I'm from IMDA, Infocom Media Development Authority from Singapore. First of all, we'd like to express our thanks to the HCCH and the Department of Justice for inviting us to be here. Thank you very much. We are honored to share about how Singapore has streamlined cross-border document attestation through what we hope will be up-and-coming way of implementing e-Apostille by the use of verified credential. Before I go into why and how we're going to apply VC to e-Apostille, allow me to paint a picture of broader context driving our work in this front. At IMDA, we see ourselves as the architect of Singapore digital futures. As you can see for the slide, the mandate is pretty broad. Generally speaking, IMDA have two domains, as our name implied, Infocom domain as well as the media domain. We have three roles actually. First, regulatory. We are a regulator in Singapore. We regulate telcos. We regulate media companies in Singapore. And of course, there's a less well-known function in IMDA. We also have a social function as well. As a society moves toward more digitalization, as society moves towards more digital economy, there's a need to ensure that a more vulnerable part of our society, the elderly, children from the less well-to-do family, continue to catch up in the modern era. So we have social function to make sure they are not left behind. And of course, IMDA have the economic function as well. We actually are responsible to develop the industry in Singapore, in both Infocom media, in Infocom as well as media. So part of what we do actually do involve providing future-ready, secure, trusted infrastructure to support a dynamic digital economy. We look beyond traditional hard infrastructure and plan the entire digital infrastructure stack. This includes what we call digital utility, which are foundational digital services provided by the government to enable citizens and business to transact seamlessly, securely, and with trust in the digital economy. Why do we call it DU, digital utility, and not DPI? In most of the world, if you Google, it's called DPI, digital public infrastructure. In Singapore, we call it digital utility because we want it to contrast with public utility. We know that in the physical world, for the physical economy to move, government need to provide public utilities such as roads, electricity, water. If not, the economy will not move. So we ask ourselves, in the digital world, in the digital economy, what do government need to provide? That's why we call it digital utility. So in Singapore, we have 4 pillars in our digital utility stack. Digital identity, how do people and business identify themselves in the digital transactions. Document attestations, how do we check the validity of digital documents. Digital exchange, how do we exchange digital information in a trusted and secure manner, as well as digital payment and invoicing, how do we pay, and more importantly, get paid in the digital era. As you may have guessed, the implementations of e-apostille span across several of these pillars. First of all, digital identity. An e-apostille has to be anchored on a specific individual or business. It attests to the document about these stakeholders. Secondary, and more importantly, document attestations. An e-apostille needs to be able to facilitate verifications of the underlying documents. And lastly, digital exchange. An e-apostille needs to be shareable across jurisdiction in a way that's secure and trustworthy. So verified credential, one of the digital utility we are profiling today, help us to achieve each of these aims. A quick 101 on VCs for those who are not familiar with the technologies. Verified credential are cryptographical signed credential which are tamper evidence, instantaneous verifiable, and globally interoperable. It is based on the trust model involving three main stakeholders: someone, an issuer, a holder, and a verifier. This is how it works. An issuer generally an authority or trusted institutions hold or can attest to data about the holder and is able to issue a trusted credential with the attribute to the holder himself. In the case of e-apostille, you can imagine that there is a government authority issuing an identity credential to the holder. At the same time, the same holder can request for an e-apostille to be issued to him in a VC format by a competent authority. In Singapore, the competent authority is the Singapore Academy of Law. The holder now hold both of these VC, can present them in a verified presentation to a verifier of their choosing. For example, a government body overseas. The verifier is able to verify and trust the validity, authenticity, and origin of this VC through checking the cryptographic signature. If any of these documents have been tampered with in the process, or the signature were not signed with the keys from the issuer, this will be evident to the verifier. All of this can happen instantaneously without needing to go back to the issuer, as a verifying process is built on an open global standards. In this way, VC meet the needs I mentioned previously: secure, trusted, digital identity, document attestation, and digital exchange. In fact, we see global traction among national government and big tech companies in using VC for multiple aspects of life. I've listed a few use cases here. For example, in education, in Singapore, we actually use OpenCert, similar technologies. Travel, provide mobile ID to clear through security checkpoints, mobile driving license, for example. Health, during the COVID period, we actually use it for our health cert. Banking, as well as edge gating. We expect momentum to build. Already, the European Union has mandated all 27 member states provide a digital wallet and digital identity to its citizens by end 2026. Other countries like US and Australia have also live implementation to identify VCs in action today. This excites my team at IMDA, and we hope to see the day where everybody can prove anything about themselves or their businesses anytime, anywhere. For us, the e-apostille initiative is a meaningful first step towards this, and we see its potential to revolutionize cross-border legal process. Moving to the work we have done on e-apostille, I want to share that we have successfully piloted the use of the VC in e-apostille with pilot authority in Shanghai. Together, we have streamlined the cross-border business registration process, thereby setting the stage to facilitate more two-way investment flow between both cities. To understand how this impacts a user on a practical level, let me walk you through the flow through before and after VCs. On the Singapore side, the issuance of an e-apostille in VC format means you do not need to visit the Singapore Academy of Law in person. To have a document checked, legalized, instead, the issuance happens online within minutes. Besides getting their legal document in an e-apostille VC format, business owners seeking to set up shops in Shanghai will also need to get a personal and corporate identity issued in VC format to serve as an anchor for e-apostille. On the China side, instead of needing to undergo further check following the submission of identifications and apostille documents, as well as needing to mail over the hard copy of the said documents, the submission of VC allowed for instantly back-end cryptographic check. For Shanghai, this reduced the need to submit hard copy documents and reduce processing time and cost. More importantly, however, it established absolute certainty of authorized signature for the very first time. Owing to the temper evident nature of VC, being able to vouch for an individual identity, authorized role, and the authenticity and validity of their documents. To wrap up, I want to highlight the benefit of using VC in e-apostille as opposed to the current method popular today. VCs are 100% machine readable. As opposed to paper or PDF, VC structure the underlying data according to a data model that can be processed entirely by computers. This means verification can happen in real time, error-free, and the end-to-end process can be fully digitalized. The use of globally interoperable standard also means there's no need to purchase or use any software just to enable verifications. Highly scalable. Building on my first point, imagine what VC can do for us at scale. Instead of waiting to receive a hard copy of a document, scanning it visually, followed by possible manual input of data, or needing to open PDF, manual clicking through steps to be able to verify signature or compare documents to documents, VCs scale very well even at thousands of documents, without compromising security due to the cryptographic proof in them. Also, as a side note, I would like to add that even with this centralized approach, VCs still keep the spirit of what is laid out in the Apostille Conventions on competent authorities, needing to be the sole designated authorities to the issuance and verification or apostille. VC facilitated this through cryptographic key pair. That's to say, a verifier of an e-apostille VC should only trust the VC and consider it valid if it was signed using a private key of the legitimate issuer, or in this case, the designated competent authority. So there's a private key and public key syncing up. Finally, VC are revocable. For some reason, there are changes to a person or business attribute, the issuer can revoke a previously issued credential. Conversely, other current method may not be able to do so immediately. In this way, the VC help contracting parties meet the requirement of the Apostille Conventions will be more efficient, cost-effective, scalable, and flexible than the current method. All in all, hopefully, we have convinced you the merit of using VC in apostille. If you're curious at all or hope to partner with us on this, we invite you to reach out to us. We'll be happy to discuss opportunity for collaborations and push this method further to the rest of the world. With that, thank you very much for your time and attention. Thank you.
Thank you very much, Mr. Liu. You have highlighted the use of digital tools, technology in implementing the Apostille Conventions and implementing the EPP. You mentioned in particular the VC, verifiable credentials. I think that is very useful tools. And Mr. Liu has also given us some examples on how apostille or e-apostille can be used in practice, and with reference to the example of Shanghai. I think that provides a very perfect conclusion for this session, because this session we discuss how the Apostille Convention can streamline cross-border document circulations, in particular for EAPP. So that is a perfect conclusion for these sessions. I'm told that we have 1 hour of time, so we cannot have any Q&A sessions, but we will have the coffee break after this panel session, so that I will encourage the participants. I have received quite a few questions actually, but the participants may approach our speakers during the break, and they can have some exchanges over the break. So that concludes these sessions. So thank you very much for all our speakers. Thank you.
Thank you. And can I please invite everyone to remain in your seat so that we can have a group photo before we take our break. And please follow the instructions from our photographers. Thank you so much. Thank you once again, Dr. Ding, for being our moderator. Thank you, Mr. Tian, Mr. Wong, Attorney Sanchez Rivera, and Mr. Ong. Thank you very much for being with us today. Wonderful. Everyone, please return to your seats. Thank you for that sharing, everyone. Appreciate it. Thank you once again. Ladies and gentlemen, we will now take a 20-minute break. Everyone, please enjoy the refreshments outside the hall, and please take all of your valuables with you when you leave. Now, for online participants, please stay logged in. The next session on the Service Convention and Evidence Convention Efficiency and Litigation Support, including through digital means, will start at 11:15 a.m. Everyone, please enjoy. Ladies and gentlemen, the second session of the symposium will begin in a few minutes. Everyone, please take your seats when you are ready. Once again, please be reminded to switch your mobile phones or electronic devices to silent mode. Thank you very much for your cooperation, and please be seated. Ladies and gentlemen, the second session of the symposium will begin immediately. Can I please invite everyone to come back to the conference hall and take your seats? Once again, please be reminded to switch your mobile phones or your devices to silent mode. Thank you very much. Distinguished guests, ladies and gentlemen, welcome back to the symposium. Now, before we begin our program again, can I please gently remind everyone not to give any applause nor to clap during the session so we can maintain a solemn atmosphere for the show to respect those affected by the fire in Taipo last week. Everyone, please be cognizant. For the next session on the Service Convention and Evidence Convention, Efficiency in Litigation Support, including through digital means, we have with us on the stage our moderator, Dr. Yang Ling. Thank you. She's the Director, Hong Kong International Legal Tenants Training Office, Department of Justice, Hong Kong SAR, and also our panelists. We have Professor Afifa Kusumadora. Thank you for being with us. Professor Gyuho Lee, and also Mr. Patala Limsila. Thank you. And Professor Tu Guangjian. Now, not only that, everyone please also note Q&A will follow the discussion. Therefore, please do submit your questions via the on-screen QR code that you're seeing on the upper right. And I will now pass the floor to Dr. Yang. Thank you.
Good morning, everyone. I'm Lin Yang, the moderator for session 2. So on behalf of the co-organizers, HCCH, and the Hong Kong International Legal Tennis Training Academy, I welcome all of you to our session. So for session 2, the topic is the Hague Service Convention and the Evidence Convention, efficiency in litigation support, including through digital means. So as all of you know that both conventions have long played a foundational role in facilitating cross-border judicial cooperation since the 1960s. They ensure the service of a process and the taking of evidence remain reliable, effective, and properly coordinated across the jurisdictions. However, today we are operating in a very different environment shaped by digital communications, electronic platforms, AI-driven tools, and rapidly evolving expectations for speed and transparency. As technology transforms legal practice, we are increasingly faced with new questions. How can digital methods enhance implementation of the service and evidence conventions? What challenges arise when moving from traditional paper-based process to electronic systems? And how can jurisdiction work together to modernize cross-border litigation support while maintaining legal certainty? Today, we are pleased to have a very distinguished 4 speakers from different jurisdictions with us to guide us through these issues from comparative, regional, and look-forwarding perspectives. Firstly, please allow me to introduce those 4 professors very briefly. On my right, Professor Afeha from University Brawijaya, Indonesia. She is a leading scholar of private international law and comparative legal studies with extensive experience in cross-border civil procedure and the application of HCCH instrument. Next, from Korean, Professor Lee. Professor Lee from Chung-Ang University Law School. He's expert in international civil procedure, cross-border service of process, and the operation of the judicial cooperation mechanisms in Korea, in United States, and China. Professor Patara from Thailand, he's the professor from Thammasat University, and his research focuses on digital governance, AI regulation, and the modernization of the judicial system in Southeast Asia, including Thailand's evolving approach to the Hague Conventions. Okay. And the Professor Guangjian, Tu Guangjian, is a professor from University of Macau. He's expert on private international law and cross-border civil cooperation, with deep insights into the judicial arrangement between Chinese mainland, Hong Kong, and Macau. So thank you all of you being with us today. To begin our session, may I invite our first speaker, Professor Afefa. The floor is yours.
Thank you, Secretary General of HCCH, Dr. Bernasconi, and Professor Yun Zhao, the representative of the Regional Office for Asia Pacific, and the moderator, Dr. Lin Yang. Good morning or good afternoon, distinguished speakers, ladies and gentlemen, and thank you for attending my presentation. So the HCCH Service Convention and Evidence Convention streamline, as we know, streamline international cooperation by replacing cumbersome diplomatic channels with direct communication between designated central authorities. However, central authority processing can be slow and service by mail or other direct means is unavailable in some jurisdictions. For example, if they object under Article 10 of the Convention. Under the Evidence Convention, a court in country A sends a letter of request to country B's central authority, which forwards to the competent court to execute it. The process can still be time-consuming, often requiring translation of requests and correspondence. The Hague Conventions have created a uniform process across jurisdictions. Thus, the conventions serve as a foundation for further reforms. Regions like the European Union have built upon Hague Convention frameworks to introduce even more efficient digital practices while keeping compatibility. Now, digital tools allow serving documents abroad via electronic means. For example, email and secure online portals in lieu of physical papers. Several jurisdictions have begun to authorize electronic service formally, however, with recipient consent. This trend can dramatically cut delays and costs by eliminating international mailing. For remote evidence gathering, courts are increasingly using video conferencing and online collaboration platforms to take evidence from abroad. Witnesses can be deposed via live video link, and documents can be shared through secure cloud repositories. The use of electronic filing systems and databases means that once evidence or documents are collected, they can be shared immediately with all parties and courts involved. This not only saves time, but improves transparency as each party can see the same information or documents concurrently. Consequently, verifying whether electronic documents are authentic and untampered becomes crucial. So, techniques like digital documents forensic, perceptual hashing, and watermarking help maintain integrity. Also, blockchain technology offers a tamper-proof ledger to record service events and evidence handling. For example, an address verification or a service delivery could be recorded as a blockchain transaction. Once recorded, it cannot be altered without detection. For example, a defendant who claims that he was never served can be confronted with a verifiable blockchain record. To ensure the authenticity of documents, digital signature technology is employed. A qualified electronic signature could carry legal effect equivalent to a handwritten signature or notarization. One major cause of failed service is wrong or outdated addresses. Artificial intelligence, or AI, can significantly improve this by cross-referencing multiple data sources to validate addresses before service. For example, an AI system might pull data from government records, postal databases, or even open sources to correct misspellings and fill in missing details. Courts and central authorities can then focus on substantive issues rather than chasing down correct addresses. Cross-border cases also often involve multiple languages. AI tools hopefully can translate legal documents, such as requests, evidence, and judgments quickly, aiding both litigants and foreign authorities. For example, a letter of request under the Evidence Convention could be translated by AI into the target language for the executing court. So it saves time and costs on professional translation. However, AI translation, while fast, are not perfect. Legal language, particularly, is nuanced, and mistakes can have serious consequences. Thus, human oversight is essential. So the recommended approach is a hybrid model. AI produces an initial translation, and then a legal editor reviews and corrects it. So this process is known as post-editing. So despite its benefits, there are some legal and technical challenges to digitalization. First, digital exchange of court documents raises privacy and data protection issues. Personal data may be sent across borders. Central authorities and courts must apply encryption and access controls. Second challenge, each country has its own law and practices, which can impede uniform adoption of digital methods. For example, some legal systems do not yet recognize electronic service or have not updated evidence rules to admit digital copies, such as in Indonesia. There are varying consent requirements for electronic service and different standards for electronic signatures. Therefore, harmonizing these frameworks is very challenging. Third challenge, on a technical level, getting different countries' IT systems to communicate seamlessly is difficult. Courts may use different software, data formats, or communication protocols. This issue also extends to authentication systems. Without mutual technical standards and certification, a document signed electronically in one country might not be accepted in another. Ongoing international efforts are aimed at developing interoperability frameworks and must ensure digital sovereignty. Fourth challenge, the risk of cyber attack or fraud now is increasing. Hackers could attempt to intercept or alter service documents or evidence in transit. There is also risk of false digital identities, which is someone impersonating a court and take others, the parties' data without their consent. So courts need to invest in cybersecurity measures and possibly use private judicial networks rather than open internet for transfers. Another challenge, digitizing cross-border procedures requires significant investment. Not all countries or courts have the budget or infrastructure. Without external support or cost-sharing initiatives, some central authorities may continue relying on paper simply due to budgetary limitation. Sixth challenge, introducing new technology in the legal circles faces human challenges. Judges, court staff, lawyers need to learn the new technology or AI tools. In some cases, there is resistance to change because legal professionals might be skeptical of these new methods. Because these challenges are universal, international collaboration is key to solving them. States and organizations should share best practices. For instance, if one country's courts successfully implemented electronic service with high security, others should learn from their model. And I think HCCH and regional bodies can facilitate this. If we make comparison between digital and traditional approaches, digital communication vastly outpaces traditional channels. An electronic service request or evidence transfer can happen in minutes or hours, whereas mailing documents overseas can take weeks and even months. By cutting out international postage and reducing paperwork, digital methods save money for courts and litigants, whereas traditional methods might involve notary and translation costs. Studies have noted that the Hague Service Convention itself made service cheaper. And we believe that digitization will further this by eliminating material costs. Digital system also brings real-time tracking to the process. Many electronic systems provide receipt or audit logs, reducing dispute about whether something was sent or received. However, there must be fallback options. For truly unreachable parties who have no known email or digital ID, traditional methods remain important. Furthermore, technology failures can occur. So in my opinion, the best approach is hybrid. Here are some examples of digitalization implication. As we know, during the COVID-19 pandemic forced an abrupt shift to remote justice everywhere. Courts that had digital infrastructures coped much better and prevented severe case backlogs. Another example, courts and judges around the world have been adapting legal interpretation to accommodate digital realities and electronic evidence. Some steps to be taken are as follows. First, collaboration and monitoring of how electronic service and evidence measures are working. Feedback loops will catch problem early. Second, policymakers should secure funding and technical support for building the necessary infrastructure. I think I finished my time, so. Okay, just 2 more slides. Sorry about it. Third, agreeing on formats for electronic forms and mutual recognition of electronic signatures and digital seals, so that one country's electronic form for a Hague request can be auto-processed by another system. As analogy is SWIFT, for example, I took analogy of SWIFT, yeah, in banking system, which is a global standard for financial messages. Well, there are some further strategic recommendation, but I think I better share my time with the other. Anyway, thank you very much for your attention. I return to the moderator.
Thank you very much, Professor Fishpa, for that very comprehensive and forward-looking presentation, especially your insights on digital transformation, the practice and organizational challenges, and the strategic opportunities for improving the cooperation of the service and evidence conventions provide an excellent foundation for our today's discussion. Next, I would like to invite Professor Lee.
Hello, my name is Gyo Lee from the Chungang University School of Law in South Korea, where the current president of South Korea graduated from. And before getting into my topic, I want to express my deepest condolence from the bottom of my heart to the lost lives and the wounded and affected families and friends in the catastrophic fire in the Taipo. Coincidentally, I was in Hong Kong in the same day of the last year. At that time, many people in Hong Kong showed the empathy with my anxiety and the frustration because the former president of South Korea declared martial law on the December 3rd. Of the last year. So my topic is how to overcome the challenges to the Hague Service Convention and the Hague Evidence Convention legally or technically from the Korean experience. So the United States has entrusted the service of process within the USA under the Hague Convention to the private agency called in the ABC Legal Services starting in this year. To me, in my opinion, it doesn't fit into the Korean system because unlike the United States, we don't follow the adversary system. On the other hand, the Minister of Justice of China has established an online submission system called ILCC.online. We need some kind of to follow this trend. I think the Korea is the well-known country for the fast culture. So almost all of the civil cases are conducted electronically in South Korea. But somehow the service process internationally doesn't fit into the Korean fast culture. So the National Court Administration sent physical letters, logatory, and other documents forwarded to the courts of all levels to the Minister of Foreign Affairs by mail, or the Central Authority by mail through the manual approval the processes, not the electronic approval processes. Additionally, the Minister of Foreign Affairs dispatched officers sort the physical mail items by country and the diplomatic mission, then send them via diplomatic pouch by air to overseas diplomatic missions. So currently, the duration required of physical documents to be sent by the mail is a minimum of the 2 to 5 weeks one way, and 1 to 2.5 a month as the round trip. And the issue of the sending, the letter of the requester must be sent by the as original as the principle. The Hague Convention on the taking of the evidence, the explicitly state, please prepare one original and one copy of this form. So, due to the differing the electronic approval systems across the agencies, the Minister of Justice and the Judiciary and the administration all together, and the mutual exchange is very difficult, almost impossible, making difficult to implement official documents and send the electronic files via the domestic request channels and the overseas diplomatic missions. So the judiciary has undertaken the digitized the consular, the service process by the early 2025. It also intends to digitize the service process request for the evidence, the Hague Service Convention and the Hague the Evidence Conventions, including the China, the Korea Civil Judicial Assistance Treaty via email files transfers between the central authorities. And least, both China and the United States has expressed their support for the Korean judiciary's plan to digitize the service of process and the request for the evidence. So those are the proposals made by the Korean judiciary. The first, they want to implement a system capable of sending original files as electronic documents. The current practice involves downloading the Hangul means Korean language formed files in accordance with the relevant regulations, preparing a request for the cooperation and the letter of request, and affixing seals. However, approving the documents electronically in the electronic litigation system could resolve the issue of the sending original documents. Hence, at the request of the Office of the International Judicial Affairs Officer, it is necessary to collaborate with the Office of Judicial Support and the Office of Judicial Information Technology to implement the ability for judicial cooperation forms to be electronically signed through the court affairs system. Secondly, the judiciary proposed the revision of established guidelines on the international civil judicial cooperations, etc. They reviewed, delete the provisions requiring physical documents to be sent by mail, partially revising the wording in the latter part of the Article 3, the paragraph 5 of the established guidelines on international civil judicial cooperation, etc. The revision might be as follows. Currently, the wording is presiding judge shall prepare the request for the assistance and summary of the documents, etc. And the revised version of UPI will be prepared via the electronic litigation system, etc. So also it proposed the review the provisions regarding preservation of the records of the cooperation activities, etc. Also, another movement is to establish interoperable electronic approval system across all agencies. Thinking about the plan to interlinking the electronic approval system, it is called ONNARA. To me, it's not working well. I don't want to use this system. It sucks. However, anyway, they're thinking, this idea used by the Korean government agencies with the judiciary system. So it is currently under review by the Judicial Information Office. Next one is the judiciary may pursue a plan to enable the issuance of the official documents by the work-related shared email. With the cooperation and approval of the Minister of Justice and the Minister of Foreign Affairs until the electronic approval system fully integrated with the executive branch. So, next one is the, next one is the, actually the, when I prepared this, the presentation, I submitted this the presentation file in the November 19th. All of a sudden, the National Assembly working very hard. All the same day, November 19th, and they proposed the submitted a bill on the international judicial manual assistance in the civil matters. So, according to that, actually, they make it some kind of the centralized, online system, and then they can like this is the cooperation of the Ministry of Foreign Affairs, that the Commission's document will be sent in the electronic files. Official corresponds to overseas the diplomatic missions. This is the contents of the bill. Okay, now let's move on to the another topic, the Hague Evidence Conventions. Korean Civil Procedure Act, which was revised in August 2021, established provisions for the holding preparatory examinations, preparatory trial hearings via the video conferencing facility or internet video conferencing systems. So this is the provisions, the prescribing the system. So video trials have been conducted a total of 164, about 154,000 times since their expanded implementation in the 2024. So in the second quarter of the 2025 alone, the 37,000, around the 37,000 video trials were held, and the making in the 46-fold the increase compared to the first quarter of the 2022. In the 2024, the number of cases easily surpassed 20,000. The video trial system was introduced under the Special Act on the Remote Video Trials enacted in the 1995. Initially, its purpose was the enable residents of the remote island and mountainous regions with a poor transportation access to receive the trials for the small claims or the summary judgment without having to travel long distances to court. The first video trial was conducted in the Gyeongju branch of the Daegu District Court, where the last APEC the summit was take place in the February 1996, almost 10 years ago, 20 years ago. Yeah, sorry. Following the revision of the Civil Procedure Rules and the Criminal Procedure Act, the video trial was used only in limited contexts, such as witness examinations and pre-trial conferences. However, 2021, in response to the spread of the COVID-19, the Civil and Criminal Procedure Act were amended again, leading to full-scale expansion and implementation of video trials. So I will skip this part. Okay, recently the several discovery-related bills were introduced to the National Assembly. According to the Hague the Evidence Convention, actually South Korea made a reservation against the free trial discovery system. However, the depositions, among between the American lawyers and the Korean witnesses, the expert actually carry out in the South Korea, but it is not a violation of the Korean Attorney Act. So now we are looking forward proactively. So one of the bills states as follows about the patent law. It we gonna adopt its German system, like this one. What is it? Expert fact-finding system. Also, we look up to the Japanese system too. So we combined the combination of the one is expert fact-finding system, modeled after the German and the Japanese model. The other is deposition, the model after the American system. My prediction is it'll be implemented the next year, not maybe the end of this year. One thing missing is actually there is some kind of the what is it? It includes privilege. Some of the bills include the privilege between the attorney and clients, but it doesn't include between patent attorney and clients. Some of the bills are criticized because among the patent attorneys. This is all I have. Thank you very much.
Thank you, Professor Lee, for your clear comparative analysis, your observations on the different approaches to electronic service and the practical challenges in Korea provide an important perspective for understanding how the conventions operate across jurisdictions. So now, may I invite Professor Patara Nimisira, please.
Before I begin, I wish to join all of you in expressing profound condolences to those affected by the recent tragedy. Our thoughts remain with the victim, their family, and the Hong Kong community. Good morning, everyone. My name is Patala Limsila. I'm assistant professor from Rangkampang University. Thank you, Dr. Yang Ling, for moderating this section. I am honored to share this panel with the distinguished professor. This is the outline of my presentation. When Thailand joined the HCCH in 2021, we became 88 members. Today, I want to address the fundamental question, how Thailand can translate this membership into meaningful participant in the Service Convention and Evidence Convention frameworks. Let me begin by explaining Thailand's current situation in cross-border judicial cooperation. Thailand had bilateral arrangement on judicial assistance in civil matters with 7 key partners for those countries. Processing typically takes a few months through central authority mechanism. However, for another jurisdiction, Thailand relies on diplomatic channels, which takes 6 months to a year and sometimes even longer. Thailand business community experience this impact, though delay directly. Yes, our current judicial cooperation system creates unnecessary delay and cost, which affect Thailand's position as a regional business hub. In today's digital age, delay in judicial document processing creates significant barriers. The efficiency gap is precisely what today's section team addresses, and convention accession offers a clear path to closing this gap. What Thailand has, Thailand is not start from zero. Let me present the evidence. Thailand already performed more functions and the convention required. First, legal framework. In 2017, Thailand amended our civil procedure code to streamline international service processing by reducing diplomatic procedure and introducing new provisions for service of documents abroad. The provision creates a modern framework that harmonizes with convention requirements. with no applicable treaty. Thai legislation on conflict of law and civil procedure allows courts to rely on general principle of private international law, committee, and due processing with dealing with cross-border service and evidence. Bilateral agreements. Thailand had bilateral judicial cooperation agreement in civil matters, though demonstrate our capacity to implement treaty obligations with concrete results. For example, our bilateral with China, our bilateral with China, in fact, since 1997, demonstrate Thailand's commitment to conduct judicial cooperation. Through this agreement and another, we have developed central authority mechanism and systematic procedure for handling international requests. Technical infrastructure. Thailand has built digital infrastructure that support modern convention implementation. Our e-filing system operation nationwide. Courts had digital case management system that track proceedings efficiently. Therefore, why Thailand have joy? Let me address 3 common misconceptions directly. First, misconception, we don't have a legal framework. This is incorrect. As I shown, our 2017 Civil Procedure Code amendment create that framework and its exit and functions. Second misconception, we don't have experience with treaty implementation. This is also incorrect. We have 7 bilateral agreements. We have been implementing those treaties successfully more than a decade. We understand how this works. Third misconception, we are not ready for digital implementation. This misconception is particularly inaccurate. We have nationwide e-filing and digital case management. More than being ready, Thailand established frameworks that could serve as model for responsive digital judicial cooperation. For Thailand digital process, let me describe recent development that demonstrate Thailand's approach to digital transformation in judicial system. Thailand is taking significant steps in AI governance for our judicial system. While countries across Asia explore different paths, Thailand is developing our own path forward. In September 2025, Chief Justice issued AI guidelines establishing clear boundaries. AI may enhance administrative and legal functions, but cannot determine case outcomes. Judges retain full decisional authority. And just 2 weeks ago, the Civil Court issued regulation on using AI system to prepare court documents. This matters because it demonstrates Thailand's approach to digital transformation. We are not simply adopting technology, we are governing it. The Civil Court regulation specifically requires for lawyers and partners and parties using AI with the 3 core ideas. First, disclosure. Lawyers must clearly identify which portion of their document were AI generated. No hidden AI content. All AI assistant works must be clearly marked with a quotation. Second, verification. Lawyers remain fully responsible with certifying all AI generated content. They must check legal citation, facts, and agreement. The AI serves as a tool, not a replacement for professional responsibility. Third, enforcement. This is quite seriously because violation account for content of the court. And the penalty is you could be in jail for violation content with the court with serious sanction. They are not merely guidelines, they are enforceable rules with meaningful consequences. Those frameworks also mandate carefully handling of professional data and sensitive information when using AI system. This demonstrates Thailand's readiness for digital convention implementation. Thailand has shown our commitment to setting responsible standards. We are prepared for digital future of judicial cooperation, and we are approaching it with carefully governance. Hong Kong as model and partner. Hong Kong offers Thailand both inspiration and practical guidelines. Your processing times for service requests set standard we seek to match. Your experience with both conventions show that careful implementation works and benefits significant outweigh the cost. Hong Kong's success demonstrates that conventions function effectively in Asian context with strong rule of law traditional. Hong Kong and Thailand already cooperate extensively in commercial matters. We have strong business partnerships, relationships, significant trade, and growing legal connections. Joining the convention framework would strengthen our relations, provide clear procedure, and greater efficiency for cross-border matters. We are not looking at a distant model. We are looking at the partner whose success shows us what is possible when jurisdictions commit to efficiency judicial cooperation enchanted by digital means. Expects outcomes. What changed when Thailand accession? Let me be specific about expectation outcome, particularly effectiveness gain with directly as day-to-day team. Processing time could be improved substantially when direct central authority communication replaced diplomatic channel. Delay could decrease to no more than 4 months. With modern digital methods, some service could occur even more rapidly. This represents the efficiency transformation that digital methods enable. Cost would be decreased. Convention framework operate more efficiently than traditional diplomatic transmission. Digital methods functionally reduce operation expense. Predictable emergence. We can provide clear time frames that serves business needs, support legal strategy. Internal standing improvement. Thai court become recognized as model efficiency and reliable partners in cross-border litigation. This enhances Thailand's attractiveness as regional business hub, benefiting our entire economy. Those are achievable goals based on proven performance from our bilateral treaty and from convention parties like Hong Kong. We are not spectacular. We are projecting based on evidence and efficiency gains that digital transformation provides. When Thailand becomes the HCCH member, we look at important steps toward fuller participation in international judicial cooperation. Thailand is ready. We have the technology, we have the framework, we have the experience. What remains is political decision to formalize those capacity through convention accession. Last, I would like to thank HCCH Regional Office for Asia and Pacific for their continued leadership and promoting international judicial cooperation across our region. I also extend my appreciation to the Department of Justice of Hong Kong for organizing this Hong Kong Legal Week and for their commitment to strengthen international legal cooperation and dialogue. Thank you, ต่อแจ๊
Thank you very much, Professor Patara. And your reflection on Thailand's readiness and the digital governance and the broader regional context and give us a very important dimension to our discussion today. Next, I would like to invite Professor Tu Guangjian to deliver your presentation. Thank you.
Okay, thank you very much. First of all, let me thank the conference organizers for your hard working and also for inviting me to be present here. Today, the topic I'm going to present is the Hague Conventions and Chinese arrangements, inspired to be further inspired and something beyond. Look at the Hague Conventions first. The Hague Service Convention concluded in 1965 and Evidence Convention concluded in 1970 are generally acclaimed as being quite successful among many Hague Conventions and also those broadly existing in the world. The Hague Conventions built up a bridge between civil law and common law countries, also between civil law countries within civil law countries as well, and facilitate international judicial and sometimes also extrajudicial cooperation in civil and commercial matters. And both conventions were made to be neutral to modern technologies. And they have set a very good example for inter-regional developments as well, such as in the EU and in the America and also in China, you will see very quickly. While trying to dismantle the borders, to me, they might have also strengthened the conceptions of sovereignty and territoriality as well. Look at this Hague Service Convention. If there is a need of serve the defendant abroad, the channels available under the Hague Service Convention are the main channels through the central authority of the request state, direct or indirect diplomatic or consular channel, postal channel, direct communication between judicial officers, officials, or other competent persons, direct communication between any interested person in the state of origin and judicial officers, officials, or other competent persons in the state of destination. And also there are derogatory channels that would be available under other international agreements and also under the more liberal law of a contracted state in the state of destination. And modern technologies can be used in many places under the Hague Service Convention. It can be used for the purpose of transmission of documents. It can be used for informal communication, and it also can be used for the purpose of service. For example, under the main channel of transmission, if the state of destination allows service by email or by other electronic means, this can be done. And also e-service may also be effected by diplomatic and consular agents in the state of destination if so allows in that state. E-service also is possible under the postal channel. Email services by postal agency shall be accepted under the convention. However, contracting states so far have very divergent opinions on service by email on other platforms and also by ordinary emails. And e-service can also be done by judicial officers, officials, and competent persons in the state of destination if the law of that state allows so. And e-service also can be available under the derogatory channels of transmission just now I mentioned. And look at the Hague Evidence Convention. If there is evidence located abroad, that needs to be taken for the use of the local court. The channels available under the Hague Evidence Convention includes taking of evidence located abroad through the central authority of the requested state, direct taking of evidence by a consul upon his own or third country's national, direct taking of evidence by a commissioner appointed by the state of origin or execution, taking of evidence by derogatory channels as well. And the modern technology, that is the video link, can also be used in many places under the Hague Evidence Convention. When the competent authority of the request state executes letter of request, video link can be used for the presence of the parties, their representatives, and the judicial personnel of the requesting authority, physically located in the state of origin. When the competent authority of the request state executes letter of request following a special method or procedure as requested, the requesting authority physically located in the state of origin may be linked by video link. They may conduct examination on the witness located in the state of execution. However, this is only possible in some states under the Hague Evidence Convention. And when a counsel accredited to the state of execution takes evidence in the state of execution, the video link can be used for the presence of the court of origin as well as parties and their representatives located in the state of origin. And when a commissioner appointed by the court of origin physically located in the state of origin, he can take evidence by video link on a witness physically located in the state of execution as well. And the video link may also be used in the derogatory channels if so allowed. In China, we have made a few arrangements for service and evidence as well. There is the service and evidence arrangement between mainland China and Macau, concluded in 2001 as amended in 2020. And there are service arrangements between mainland China and Hong Kong and between Hong Kong and Macau, respectively, concluded in 1998 and 2017. And there is also the evidence arrangement between mainland China and Hong Kong, concluded in 2016. So actually, the interregional arrangements of China have learned from the Hague Conventions. The arrangements were made in a semi-international way at the time and have many provisions similar to those in the Hague Conventions. One might say all these arrangements are slimmed down versions of the Hague Conventions compared with the EU regulations, which are enhanced versions. For the purpose of cross-border service, all the concerned arrangements establish the channel between the courts of the two concerned parties, which is partly similar to the Central Authority channel and partly similar to the channel of Article 10, Paragraph 2 of the Service Convention, but without mentioning any other possible channel. For the purpose of cross-border taking of evidence, the concerned arrangements establish the channel between the courts or the liaison organs of the two concerned parties, which is similar to the channel available under Chapter 1 of the Evidence Convention, without mentioning any other possible channel as prescribed in the convention, but with an innovation that between Macau and mainland China, witnesses can be transported to the requesting side under the help of the requested side without compulsion. New technology, that is electronic means, has been introduced into the service and evidence arrangement between mainland China and Macau for transmission of documents and informal communications as under the Hague Conventions. And electronic platform has already been built up between the two sides for such purposes. And a video link and even voice link can be used for taking of evidence under the arrangement. Apart from this, we can have more to learn from the Hague Conventions. First of all, we are not still clear about the nature of the arrangements. The Hague Convention, the Service Convention, is said to be non-mandatory but exclusive. And the Evidence Convention, still not clear about whether it is mandatory or not. And we are not sure about the nature of our arrangements. And sooner or later, we need to make clear for this as well. And a service by mail, in my opinion, can be written into the arrangement, because EMS court service in the mainland has already been practiced for long and broadly, and the two SARs didn't make any objection to mail service under the Hague Conventions. And to me, this can be perfectly written into the arrangements to expand the channel. And direct taking of evidence can also be allowed, at least on voluntary witnesses without compulsion, because within one country, I think the judicial sovereignty should be weakened. Service by electronic means, for example, postal email or email on the commonly built platform, can be used, can be explored, and a video link for taking of evidence can be more broadly employed under the arrangements. Something beyond, we can learn from the Hague Conventions, and we can also do something more than the Hague Conventions. Before that, let's look at some recent developments. Look at the domestic developments in the mainland China. According to Article 91 of the Chinese Civil Procedure Law, as amended in 2023, service by electronic means is allowed with the consent of the parties to be served. Article 285 of Chinese Civil Procedure Law, paragraph 11, according to which service by electronic means is allowed to serve the defendant abroad if the country of destination doesn't object. And according to Article 286 of Chinese Civil Procedure Law, paragraph 3, Chinese courts can take evidence located abroad by instantaneous telecommunication means with the consent of both parties if the country of destination does not forbid this. Generally, nowadays, one must say electronic means have been broadly and frequently used in the judicial practice for service, delivery of court documents, court hearings, and informal communications in the mainland China. Look at Hong Kong. I know I'm not an expert for Hong Kong law, but according to my observation, at least one case in which you can see the use of video link is acceptable. And also look at the Macau Civil Procedure Code, Article 126, paragraph 4. You can see e-service is also acceptable. And look at the latest responses of mainland China and Hong Kong to the Hague Conventions. Because Macau didn't respond to the questionnaire, so no information for this. Look at the information for mainland China. To enhance the efficiency of judicial assistance in civil and commercial matters, the Ministry of Justice has launched an online civil and commercial judicial assistance system through which, I quote here, foreign requesting parties may submit judicial assistance requests, track their status at any time, and download the results of execution in real time as we receive, review, and update requests on our end. And China's central authority can accept electronic incoming transmission of documents, although so far China didn't make any outgoing electronic request. And China has made a reservation for incoming postal channel service, but it may make outgoing postal channel service. As the state of destination, China allows execution of service by electronic means, but unclear about the use of video link for assisting in taking of evidence. And in Hong Kong, still, Hong Kong is using the manual case management system for tracking both outgoing and incoming requests. Electronic outgoing and incoming transmission of documents are not practiced in Hong Kong either. As the state of destination, personal service is used as the default rule in Hong Kong, and electronic service not practiced on the main channel either. Incoming postal channel service is allowed. As the state of destination, taking of evidence by video link, however, may be requested as a special method under Chapter 1. Then what can we do for Chinese interregional arrangements? That can be more than the Hague Conventions. First of all, I think contractual agreement service may be accepted and written into the arrangement, because as far as I know, contractual agreement service is allowed in Hong Kong, and that is also allowed in mainland China. And a uniform electronic platform among the three regions can be established for transmission of documents at least, and even for service by email or video link taking of evidence. Apart from this, a uniform electronic platform database among the three regions can be established holding data such as personal IDs, registers of immovables, registers of cars, registers of matrimonial property relationships, registers of companies, etc., which can be fundamental and important evidences for judiciaries. And this has proved to be feasible by the health code invented during the COVID-19 pandemic. Conclusions. As demonstrated above, the interactions between The Hague and Chinese practices can be beneficial to both. Looking to the future, modern technologies shall be more made use of to enhance the efficiencies of the Hague Conventions and also the Chinese arrangements. Chinese interregional judicial cooperations shall be more developed and done more closely and deeply than those done at the international level. Thank you very much.
Thank you, Professor Tu. Your analysis of Chinese mainland, Hong Kong, and Macau arrangements on the service and taking of evidence and their relationships with the Hague Conventions provides us a very meaningful regional perspective and to today's discussion. So I'm cautious about time, and actually I got a number of questions from audience. If I may, please allow me to announce we conclude today's session. I would encourage all the audience to ask questions after this session to our distinguished speakers. So last, I would thank all the speakers today and for your inspiration, contribution, and sharing with us. Thank you.
Thank you very much, all of you. And can I remind everyone to remain in your seats? I believe the videographer probably wants to take a video before we wrap up, as well as our photographer. Everyone, thank you. Thank you. And just one final photo. Thank you very much to our moderator as well as our panelists. Everyone, please be seated. Thank you once again. Appreciate it. Distinguished guests, ladies and gentlemen, a symposium of the HCCH Regional Office for Asia and the Pacific on private international law has come to an end. Now, on behalf of HCCH, the Department of Justice of the Hong Kong Special Administrative Region, we would like to express our deepest gratitude to all of our speakers, as well as to all of our moderators for their insights and valuable contributions today. We have also extended our thanks to every guest who participated today that are with us both in person as well as being online. And please be kindly reminded that before you leave, we would like to invite you to complete the feedback form by scanning the QR code that is on the screen. And also online participants, you can complete it online. When leaving the conference room, everyone, please do return the interpretation headsets to the service desk at the entrance and take all of your personal belongings with you. Now, for in-person participants who require continuing professional development CPD credits from Law Society of Hong Kong or Advanced Legal Education ALE credits from the Hong Kong Bar Association, please present your QR code outside the conference hall to register your departure and confirm your attendance record. Sorry, just one moment, everyone. I believe we have an update. And before we send you off for the lunch break, I believe we do have a conclusion for today's symposium with my deepest apologies. Now, everyone, without clapping, however, can we please welcome with a nod to invite Professor Zhao Yun, representative HCCH Regional Office for Asia and Pacific, to deliver the closing remarks. Everyone, please refrain from clapping. Just a gentle nod will do. Thank you very much. Professor Zhao?
Thank you. Dear colleagues, ladies and gentlemen, it is my great honor to deliver the closing remarks today. First,
On behalf of the Hague Conference on Private International Law, I would like to express our sincere gratitude to the Hong Kong SAR government for providing this opportunity to convene in this dynamic international hub. Hong Kong's commitment to the rule of law and international legal cooperation has provided an ideal backdrop for our discussions. Our thanks also goes to every participant, government officials, judges, academics, and practitioners from across the Asia-Pacific region. Your expertise and active engagement have been instrumental to the success of this event. This symposium aims to promote and further develop the understanding of private international law and the rule of law in our region. This morning, we engaged in in-depth discussions on the practical cooperation and future directions of the 3 cornerstone conventions for transnational litigation and Apostille. Our discussions were both insightful and forward-looking. Regarding the Apostille Convention, we heard about successful practices from jurisdictions within the region, particularly on the significant practical benefits derived from the streamlined system of authentication introduced by the Convention. The continued successful implementation of the Convention strengthens our resolve to explore initiatives like the EAPP. A clear consensus emerged from the discussions. Contracting parties have gradually modernized their e-government solutions, including through the issuance of the e-apostille and the establishment of e-registers. These efforts are consistent with global trends in the use of information technology. As this digital transformation is ongoing, states may find themselves at different stages of implementation. A key takeaway from recent discussions is the need for continuous learning and the exchange of expertise. Contracting parties are therefore strongly encouraged to share their developments with one another and together, further modernize the way documents are produced and used worldwide. The experiences shared by several jurisdictions in implementing components of the EAPP provide valuable blueprints for others. We recognize that achieving the request will also very important. This requires not only technical solutions, but also building trust and addressing cybersecurity concerns. Concerning the Service Convention, practices demonstrated that using information technology represents a pragmatic way forward. We emphasize the role of central authorities as facilitators, not bottlenecks, and explored how to enhance judicial cooperation through the Convention's direct channels. A key conclusion is that the Convention's inherent flexibility, guided by a spirit of cooperation, is that the Convention's inherent flexibility, guided by a spirit of cooperation, is the greatest strength in the digital age. Our discussions candidly address persistent challenges, such as delays and refusal of service, while also highlighting innovative solutions. These conventions were adopted at different times and represented a great improvement from the diplomatic or consular transmission mechanisms. The Service Convention was the first HCCH convention to establish a system of central authorities, and that has greatly improved the transmission of requested and the time required for serving documents. With the developments in digital communication, contracting parties are encouraged to consider solutions to streamline even further the communication between all authorities involved. Using the IT for the transmission and execution of requests, as well as for resolving associated matter, is a key. The dialogue on the Evidence Convention was particularly timely. We examined the delicate balance between efficient evidence-taking and respect for fundamental principles of state sovereignty and data privacy. The potential of using video conferencing and other remote technologies is immense, but must be harnessed within a framework of legal certainty. Discussions on the interface between the Convention and emerging data protection regulations were especially pertinent. There was agreement on the need to further provide the guidance on how to help the judges and practitioners navigate this complex intersection. You may wish to know the importance of the e-country profile. They will provide the guidance necessary for navigating the use of IT, including for the taking of evidence by video link. Therefore, a powerful cross-cutting theme emerged: the need for a technology-enabled approach to our successful conventions, one that is fundamentally based on enhancing legal certainty and predictability. Looking ahead, our path is clear. First, the innovative practices discussed today should be disseminated. In this regard, we recommend the practical guides and handbooks developed by the HCCH. Second, we will foster networks to support and encourage capacity building within our region, particularly for judiciary at the forefront of applying these conventions. Third, we must continue to support the universality of these instruments. As their benefits are multiplied with each new accession, we are confident that we will soon see more jurisdictions from our region joining these conventions. Ladies and gentlemen, the active participation from the Asia-Pacific region at this symposium underscores its critical importance to the HCCH. From China's successful integration into the Apostille system to the pioneer roles played by Philippines, the Republic of Korea, and Singapore, and many other jurisdictions, our region is a powerhouse of legal innovation and cooperation. The HCCH is committed to deepening our partnership here through tailored technical assistance and regional focus and forums. In conclusion, the success of the HCCH depends entirely on you, our members, our practitioners, and our scholars. As you return to your city and your office, I urge you to carry the insights gained in Hong Kong into your work. Let us continue to work together to ensure these conventions remain living instruments, effectively serving the needs of a globalized world. I would also like to thank the Department of Justice for the strong support in the past years. I would in particular emphasize the importance of continued collaboration with the Hong Kong International Legal Talent Training Academy of the DOJ. Thank you for your invaluable contributions. It is my pleasure to announce that this HCCH Symposium has now come to a successful conclusion. I wish you all a safe journey home. Thank you.
Thank you very much, Professor Zhao, for the wrap-up and the food for thought for everyone in the audience. As I mentioned, everyone, the Symposium of the HCCH Regional Office for Asia and the Pacific on Private International Law has come to an end. And I will say it again, I would invite everyone to please fill out the feedback form, as your feedback is extremely important to us. So everyone, please do scan the QR code to reflect some of the opinions that you might have. And again, when leaving the conference room, please do take all of your valuables with you. And for those of you who require continuing professional development, CBD points from the Law Society of Hong Kong or advanced legal education, ALE credits from the Hong Kong Bar Association, please do present your QR code outside the conference hall to register your departure and confirm your attendance record for that to happen. Again, thank you very much, everyone, for joining us in person and also online. The HKLW events will continue this week, including the Capital of Mediation event this afternoon. Everyone will reconvene after. Thank you very much.
check, 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 check. Check, check, check. 好。
Honorable guests, ladies and gentlemen, good afternoon. Please be kindly reminded that the afternoon session will begin shortly. Everyone, please be seated and please double check to make sure you switch your electronic devices, including mobile phones, to silent mode. Thank you very much. Please note, simultaneous interpretation in Putonghua and Cantonese is available. For those of you who are with us at the HKCEC, headsets are available at the hall entrance. And if you're participating online, you can choose the preferred language channel on the Hong Kong Legal Week website. For in-person participants who require continuing professional development, CPD credits, or advanced legal education, ALE credits, please make sure to present your QR code outside the conference hall to check in and check out before leaving. Also on the screen, you'll find the QR code to access today's program. You'll see the Q&A sessions and the evaluation form as well. We hope you can share your feedback with us after the event. Thank you very much for your attention. Good afternoon, honorable guests, ladies and gentlemen. Before we begin our program for this afternoon, I would like to invite everyone to join me in observing a moment of silence. As we know, last week, a terrible fire in Taipo claimed many lives and left many injured. Let us take a moment to remember those who lost their lives, those that are still recovering, and all the families and those individuals affected by this tragedy. In order to maintain a solemn atmosphere to show our respect to all of them, everyone please refrain from giving applause or clapping hands during the conference today. May I now invite everyone to please stand up to observe a minute of silence with me. Thank you, everyone. Please be seated. Everyone, welcome to the session of Capital of Mediation. In this session, we'll explore the important role of mediation in the global context and also within our local communities. Now, without further ado, may I invite the Honorable Paul Lambton Kwok, GBS, SCJP, Secretary for Justice, the Government of the Hong Kong Special Administrative Region of the People's Republic of China, for the welcome remarks. SJ, please.
Distinguished guests, ladies and gentlemen, thank you for joining us today to discuss Hong Kong's unique and visionary status as the capital of mediation. And I apologize for my voice. Hong Kong as the capital of mediation is not merely an aspirational slogan. A status built upon a foundation of strong national backing and a distinct identity, rooted in history, reinforced in practice, and recognized in policy. The 14th Five-Year Plan expressly supports Hong Kong's development as a center for international legal and dispute resolution services in the Asia-Pacific region. This national endorsement provides a momentum for us to leverage our unique position and project our robust rule of law globally. Hong Kong's development in mediation began with the civil justice reform initiated in the early 2000s and the pioneering work of the Working Group on Mediation headed by the then Secretary for Justice. These early efforts mark a decisive cultural shift in our legal landscape, from litigation being viewed as the default mechanism for dispute resolution, trust embracing mediation as a primary preferred approach that serves the interests of all parties involved. Today, Hong Kong has built an exceptionally mature mediation culture, anchored by comprehensive legal infrastructure. And effective since January 2013, the Mediation Ordinance provides a robust regulatory framework for mediation, ensuring that it remains a process characterized by confidentiality, flexibility, and reliability. Complementing this is the innovative Apology Ordinance, introduced in 2017, which facilitates reconciliation by allowing expression of apology without admitting liability. These developments have been powered by concerted efforts across the Department of Justice, the judiciary, and other key institutions to make amicable settlement the preferred path to justice. The Hong Kong judiciary also plays a vital role in promoting mediation as a key dispute resolution tool. Through initiatives like Practice Direction 31 and the establishment of integrated mediation offices, our judiciary encourages parties to resolve conflicts efficiently and amicably. This supportive stance reflects Hong Kong's commitment to fostering a culture of settlement, reducing litigation costs, and enhancing access to justice. With a solid and long-standing foundation in mediation, amplified by strong national support, Hong Kong excels as an international mediation hub and as a super connector between the Chinese mainland and the international community. We serve as a bridge between the common law and civil law system, not in theory, but also in practice. Under the Closer Economic Partnership Agreement, CEPA, for example, we have established a specialized mediation mechanism for cross-boundary investment dispute, giving Hong Kong investors and mainland enterprises an efficient and culturally attuned channel to resolve differences and facilitating integration and building commercial trust along the way. To ensure this ecosystem thrives from the ground, the Department of Justice vigorously promotes a mediate-first culture. Key initiatives include the Mediate First Pledge campaign, which encourages businesses to explore, to adopt mediation as a first resort to resolving dispute. The biennial Mediation Week, which raises public awareness in sector-specific use of mediation, and a government-wide policy requiring mediation clauses to be incorporated in government contracts. Together with a strong and growing pool of over 2,300 accredited mediators, these efforts are building a dynamic, self-reinforcing mediation culture. And we carry this story to the world. Through targeted delegations and duty visits across Southeast Asia, Europe, and the Middle East, we are not just promoting our services, we are sharing successes, forging new partnerships, and issuing a compelling invitation to the world to collaborate with us in advancing the future of dispute resolution. This is a commitment to building a global community grounded in harmony and constructive problem solving, the exact principles that Hong Kong is uniquely positioned to model and lead as the capital of mediation. In addition to the above initiative and development, what has set Hong Kong apart from any other mediation center in the world and make it the capital of mediation is by hosting the International Organization of Mediation, or in short ROAP, headquartered right here. The ROAP is the world's first intergovernmental legal organization exclusively dedicated to mediation as a means for peaceful resolution of international dispute, filling an important institutional gap that previously existed in global mediation. Since the signing ceremony of the ROAP Convention held in Hong Kong on the 30th of May this year, attended by around 400 representatives from 85 countries across Asia, Africa, Latin America, and Europe, including officials at a ministerial level from over 30 signatories, as well as high officials from around 20 international organizations. The convention has already come into effect in August, with ROAP commencing actual operation on the 20th of October this year. Within just 5 months, the ROAP achieved the milestone of signing, coming into effect, and beginning operation. an exceptionally rapid pace in the history of international organization establishment. This fully demonstrates that the establishment of RMAC is in line with the trend of the times and had received widespread support and positive responses from the international community. The RMAC will mediate dispute between state or between a state and foreign investor and international commercial dispute based on the will of the relevant parties. Its establishment signals a new era for mediation. It institutionalized mediation at international level, providing a treaty-based framework that enables state and private parties to engage in bespoken, voluntary mediation processes with the assurance that the outcomes are respected. As Foreign Minister Wang Yi aptly remarked at the RMAC signing ceremony, Hong Kong was chosen and trusted by the international community to host the RMAC for our unparalleled strength in international mediation, our affinity to the motherland and connection to the world, our enabling business environment and highly developed legal system. The value of mediation and the role of Hong Kong will be further highlighted during the discussion to follow. Today's discussion will start with the keynote address by Mr. Apostille, General Counsel of Asian Infrastructure Investment Bank, who will tell us how multilateral development bank and international organization can engage with mediation. The first session will then examine mediation's rising significance in international dispute, both between state and among private entities, and how tailored frameworks could facilitate the process, as illustrated by the RMAC mediation rules. The second session will turn the spotlight to our city's own initiative, including the government's effort to deepen mediation culture and diverse community mediation application. As we embark on today's discussion, let us remember the spirit that underpins the capital of mediation, the spirit of collaboration, respect, and relentless pursuit of peaceful solutions that benefit all. Thank you very much.
Thank you very much. SJ, please be seated. Thank you very much for the remarks. Now, following the welcome remarks by SJ, we have Mr. Alberto Nino, General Counsel of the Asian Infrastructure Investment Bank, who is joining us to share his insights. Mr. Nino, please. Thank you.
Very good afternoon. And let me thank, first of all, Secretary and Honorable Paul Lam Ting Kwok, Secretary of Justice for the Government of Hong Kong, for once again invite AIIB and in my name to be here this afternoon. It is a profound, profound honor to return to Hong Kong this year and address you at the capital of mediation. And I think this is much of a reality as it is an aspiration. We can see a lot of the elements for mediation already taking place in Hong Kong. I'm going to tell a little bit how this relates to the work of multilateral development organizations in a moment. But before I start, please accept my profound condolences for the tragic events that took place in Hong Kong a few days ago. My deepest sympathies for those that have been touched by this tragedy. I also would like to extend my appreciation to the Department of Justice for the invitation and for this important event, which brings together leading minds in law, dispute resolution, and international cooperation. Hong Kong's role as a global hub is further cemented by gatherings such as this, and I'm privileged to contribute with a few elements for an evolving discussion on the international law. So Hong Kong as a capital of mediation. Hong Kong's emergence as a capital of mediation is no accident. It's not by chance. Its common law tradition, robust legal infrastructure, and strategic location have made it a natural center for international dispute resolution. The city's commitment to promoting mediation is reflected in its hosting of the new International Organization for Mediation, IOMED, a landmark institution dedicated to support the resolution of international disputes through mediation. Very dedicated through mediation. It's really one of its kind. Hong Kong's legal system, rooted in a common law tradition, provides a stable and predictable environment for resolving disputes. This tradition, inherited from its historical ties and continuously developed through local jurisprudence, ensures that parties from the diverse jurisdictions can find common ground and trust in the city's legal process. The judiciary's independence and the availability of highly qualified legal professionals further enhance Hong Kong's attractiveness as a dispute resolution center. Moreover, Hong Kong's strategic location positioned itself as a gateway for international commerce and investment. The city's connectivity, both physically and digitally, allows it to serve as a bridge between different legal systems, cultures, and economic interests. This unique position is complemented by a government that actively supports the development of mediation and other forms of alternative dispute resolution, as we heard from Secretary Paul Lam. The establishment of IOMED in Hong Kong is a testament to the city's leadership in this field. IOMED's mandate to facilitate the peaceful resolution of international disputes through mediation aligns with Hong Kong's vision of being a center for legal excellence and innovation. The city's investment in mediation training, public awareness, and institutional support has created a culture, and that's very important, a culture where mediation is not only encouraged, but celebrated as a preferred method of dispute resolution. Again, this does not happen by chance. If you look at the history of mediation, you can look at these summaries, and that started with Mesopotamia, where there was a feeling that mediation would be the best way of solving disputes. So today, mediation is utilized in various contexts, including civil disputes, labor relations, and even complex negotiations within communities. Its growing significance reflects a broader societal trend towards peaceful resolution and conflicts, highlighting the value of mutual understanding and compromise. And again, compromising is the key word here. Mediation has been a part of human interaction that has evolved with civilization. If we take a look at history of mediation in several parts of the world, we'll see that happening, particularly starting from the Middle East, but also in Asia. If you look, for example, at biblical Israel, a classic case of alternative dispute resolution in history can be traced to the Kingdom of Israel, around 960 before the Common Era. King Solomon stood as a mediator between two women. The dispute is probably the most famous child custody battle in history. In that scenario, two women fought over a child's rightful motherhood. King Solomon stepped in and offered a solution that would favor both women equally. This unbiased approach to conflict resolution makes a mediator practically indispensable in cases that get settled out of court. Furthermore, if you look at Sharia's law under the Muslim world, it also supports the role of mediator in its conflicts. The rule of thumb is that mediator must be unbiased and have no stake in the dispute. They should only resolve disputes by suggesting ideas and offering solutions to the disagreeing parties. The decision to accept or reject the mediator suggestion lies with the specific parties. There is no compelling of accepting a solution. For other mediation instances in the Middle East, we consider Prophet Muhammad's life. Many scholars assert that during Prophet Muhammad's early life, tribes were warring over the Kaaba reconstruction and chose him as a mediator. The Prophet calmed the storm looming over the tribes by suggesting a solution that accommodated both parties' interests. If we look in mediation in China, Confucius, as a philosopher who believed that respect for one another trumped the superiority of the law and its associated conflicts. During his time, some scholars believe that China fully supported mediation. The philosopher always advised that the best solution to conflict was ethical reconciliation, also a word used by Secretary Lam. So the relevance of mediation in modern society is vital today. From the workplace to communities and families, mediation helps individuals to settle their differences effectively. It affords quarreling parties a rare glimpse into each other's viewpoints. The clarity that mediation brings is seldom present in judicial hearing, which ends up privileging conflict. Mediation and mediators are relevant today because of many reasons, and some of them include empowerment, confidentiality, the quality of the resolution, and the speed of settlement. That's all what we lawyers and practitioners of law, look for a good outcome. Court proceedings can take months and even years to resolve, and the longer it drags on, the more legal costs one incurs. These outlines reasons prove the relevance of mediation in modern society. Besides, every business and individual want to avoid unnecessary legal costs and protracted court battles. As a result, more people are hiring the services of experienced mediators today. And again, Hong Kong provides an ideal setting for this. So that brings me to the role of multilateral development banks, which is the area that I have been working for a long time in mediation. And we do use mediation formally and informally in many, many ways. It could be commercial disputes, it could be investment disputes, but also could be in disputes with communities, also disputes with staff that might, be happy with decisions that the organization made. So I outline at least 4 ways in which mediation does play a role in the work that multilateral development banks do. MDBs play a pivotal role in fostering sustainable development, cross-border investment, and international cooperation. As these institutions operate across diverse jurisdictions and cultures, disputes, whether contractual, regulatory, investment-related, or staff-related, are inevitable. The ability to resolve such disputes efficiently and amicably is essential for maintaining trust, stability, and progress. Multilateral development banks such as the Asian Infrastructure Investment Bank, or AIIB, the World Bank, the Asian Development Bank, and so many others are at the forefront of financing projects that drive economic growth and social development. These projects often involve multiple stakeholders, including governments, private sector entities, and civil society organizations. The complexity of this relationship, coupled with scale and scope of MDB finance projects, increase the likelihood, and it does happen, of disputes arising at various stages, from project conception to implementation to operations and maintenance. AIB established by a multilateral treaty, and it is headquartered in Beijing back in 2015. It has been operational now for 10 years. It exemplifies the legal complexities faced by MDBs. Its articles of agreement, its charter registered with the United Nations, grant its full juridical personality and the capacity to contract, acquire property, and engage in legal proceedings, and at the same time maintaining legal privileges and immunities. AIB's operations are underpinned by the treaties, international conventions, customary law, and general principles of law, ensuring that its activities adhere to the highest standards of transparency and accountability. The legal framework governing MDBs is unique. It started with the World Bank, with the Bretton Woods Institution organization back in 1944, and offers them privileges and immunities necessary for their independence and functioning. At the same time, MDBs navigate the domestic laws of countries in which they operate. This duality creates a complex legal landscape where disputes can frequently arise. Again, we have mediation as a way to approach and as a way of resolving issues, not the courts. AIB and other MDBs increasingly recognize mediation as one of the methods to be considered for resolving disputes. It offers flexibility, confidentiality, and the opportunities for the parties to craft mutually beneficial solutions in a speedy way. The advantages of mediation in the MDB context are manifold. Mediation allows parties to maintain control over the outcome, fosters dialogues and understanding, and preserves relationships that are often critical for success of long-term development projects. Let's just remember that MDBs are comprised of countries, and those countries will continue to be members even though there could be disputes. This is particularly important in the international development arena, where the ultimate goal is to achieve positive social and economic impact. Throughout my years of service, first at the World Bank and now with AIIB, I witnessed the advantage of incorporating mediation in both its internal justice system and external operations. For example, The International Center for Settlement of Investment Disputes, ICSID, based in Washington, housed by the World Bank Group, that many of you are familiar with, offers a neutral and dependable forum for arbitration, conciliation, and enforcement of awards, which helps to encourage foreign investments. However, it is important to acknowledge that no dispute resolution mechanism is without challenges. For example, some critics have pointed to concerns about the cost and duration of arbitral proceedings. That's why I think that the mediation discussion this afternoon is so important, as well as questions regarding transparency and consistency in decision-making. These challenges underscore the need for multilateral development banks to continuously evaluate and refine their approaches to dispute resolution, such as mediation, ensuring that they remain responsive to the evolving needs of the stakeholders. The World Bank approach has influenced the development of dispute resolution frameworks in other MDBs. The adoption of mediation seems to me the next frontier as a primary tool for dispute resolutions to reflect a broader trend towards collaborative, non-adversarial methods in international development finance. This trend is driven by a recognition that sustainable development requires not only financial resources, but also effective mechanisms for managing differences and building consensus among diverse actors. Public international law provides the foundation for mediation in cross-border disputes. Article 33 of the UN Charter identifies mediation as a primary means for peaceful settlement of disputes. And I'm sure this was a big inspiration for IOMAT. The principles of consent, neutrality, and respect for sovereignty are also central to effective mediation. Multilateral development banks, as international organizations, must navigate complex legal landscapes, balancing the interests of member states, investors, and affected communities. Mediation offers a pathway to consensus, enabling parties to resolve differences without resorting to litigation or arbitration, which can be costly, time-consuming, and adversarial. The establishment of IOMAT marks a watershed moment in the evolution of international dispute resolution, no doubt. With more than 30 founding members, including China, and headquartered here in Hong Kong, Special Administrative Region, IOMAT is the world's first dedicated intergovernmental legal organization dedicated solely to mediation. Its rapid establishment, as described by Secretary Lam, and broad support reflect the global demand for innovative, flexible, and effective mechanisms to resolve international disputes. IOMAT's creation is both timely and necessary. As international relations become more complex and multipolar, the need for effective dispute resolution grows. The proliferation of cross-border transactions, the rise of new economic powers, and the increasing interconnectedness of global challenges, such as climate change, public health, we saw with the COVID-19 challenge, and the digital transformation, have heightened the potential for disputes that transcend national boundaries. In this context, mediation offers a constructive alternative to confrontation and litigation. IOMAT's principle of consultation, joint development, and voluntary participation align with the goals and principles of the UN Charter. Its structure comprising a governing council, secretary, and panel of mediators ensures a robust governance and operational capacity and impartiality. The organization's emphasis on inclusivity and diversity in the selection of mediators reflect a commitment to fairness, and also it works to complement the efforts of other international organizations such as the United Nations and ICSID. As we look ahead, the role of mediation in international development is expected to grow in importance. MDBs like AIIB must continue to innovate, adopting best practice, and collaborating with institutions such as IOMAT. Mediation's flexibility, efficiency, and capacity to build consensus make it indispensable for addressing the challenge of our interconnected world. The future of mediation in international development is promising, but it does require sustained commitment and investment. Governments, international organizations, and the private sector must work together to create enabling environments for mediation to flourish. This includes developing supportive legal frameworks, investing in mediator training, and promoting public awareness of mediation's benefit. These areas, AIB is very interested in collaborating with any organization present here today. For this to happen, it's important that nations, business, people, and international organizations embrace mediation as a category of public good, where to mediate first and fight later should become a norm and not an exception. Hong Kong's leadership as the capital of mediation is both a recognition of its achievement and a call for action. By embracing mediation, we can build bridges across divides, resolve conflicts peacefully, and promote sustainable development for all. On November 3rd, 2025, Mr. Jin Li-Chun, the president of AIB, announced during the FinTech Week event at this convention center that AIB will open a new office here in Hong Kong. This strategic decision demonstrates AIB's commitment to utilizing Hong Kong's vibrant capital markets, world-class professional services, and strong legal infrastructure and tradition to support its expanding operations in projects financing, investment, and dispute resolution. Let's all work together to advance the cause of mediation, strengthen international cooperation, and ensure that our institutions remain responsive to the needs of our time. I'll stop here. Thank you very much.
Thank you, Mr. Nino. Thank you for that sharing. Please be seated. From a global standpoint, this session explores mediation's critical role in resolving interstate disputes, as well as international investment and the commercial conflicts between states and private entities. This demonstrates how effective mediation fosters peace, it fosters stability, and shared economic prosperity worldwide. Now, the speakers in this session, they will come on stage later and they will share and present their views on this very subject. Please note that there will be a Q&A that is at the end of the discussion. And for on-site participants, you can scan the on-screen QR code that is on the right later on, and you can submit your questions for the Q&A QR code. Now, for the online participants, you can submit the questions in the chat box directly. Now, as we are setting up, can I just kindly remind everybody there will be no applauses and there will be no clapping in this event for today, so we can maintain a more serious and a more solemn tone for this week. Thank you very much, and we highly encourage everyone to ask questions, and we hope to address it as much as possible at the end of the Q&A or at the end of the panel, depending on time. I do understand that sometimes time is the essence and we cannot take all questions. So please do bear that in mind as well. All right, and it looks like we're almost ready. Now, everyone, please welcome with me and invite the moderator of this panel, Mr. Rimsky-Yun, GBM, GBS, SC, JP, to be on stage. Mr. Yun, please. And please refrain from clapping. Thank you very much. And I will hand the stage over to you.
Ladies and gentlemen, thank you for joining this session, which is the first session of this afternoon after the keynote speech. The title of this session is A World in Dialogue, Mediation for Peace and Prosperity. Personally, I think this dialogue is very, very appropriate because if we look around the world at this time, there are certain areas where I'm sure a majority of people, if not all of us, would want to see more peace rather than what is going on in certain areas of this world. And today we are privileged to have two experts who would share with us their views on mediation in the context of international dialogue. The first one, without further ado, is, if I may introduce, Professor Yi, who is a professor and director of the Chinese Institute of International Law at China Foreign Affairs University, and also the co-facilitator of the expert group on the IOMED rules on state-to-state mediation. So Professor Yi, perhaps if I may hand the floor to you first, and then we would be grateful if you can share with us your views on the topic in question. Thank you, Professor Yi.
Ladies and gentlemen, it's a great honor for me to be here today to share with you some of my thoughts on the idea of mediation, and then to give you a sneak review of some of the articles in the IOMED Convention and the mediation rules that I helped draft. Now, let's go quickly to the idea of mediation. Usually we'll see that there's a narrow view and a broad view of mediation. We probably have heard a few times already Article 33 of the UN Charter, which states that the parties to any dispute shall, first of all, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, blah, blah, blah. Okay? This provision, in my view, reflects a narrow view of mediation because it's listed together with inquiry, mediation, and conciliation, and other means. A broad view will include inquiry and conciliation together in this idea. And as we go along, we will have a better idea of what it's all about. Now, let's take a look at the place of mediation in the international dispute settlement system. In the speech given to you by Mr. Nino, you have already heard quite a bit on this. Usually, particularly in the domestic legal order, we say that judicial settlement is the main means of dispute settlement. All other things are alternatives, right? And when I started teaching in the West, I was asked to design a course on alternative dispute settlement in international law, and I was kind of puzzled, right? And then when I came back to China, trying to do some things and interacting with scholars, actually one scholar told me that, Senho, judicial settlement of disputes is the main means. Why don't you take a look at Article 36 of the UN Charter, which says that when the Security Council decides to help dispute settlement, in making recommendations under this article, the Security Council should also take into consideration that legal disputes should, as a general rule, be referred by the parties to the International Court of Justice in accordance with the provisions of the statute. Now you see, this says it's a general rule. If judicial settlement is not the main means, what do you mean by the general rule, right? I was also a bit puzzled, right, because it is not, I usually would have heard about as justification for the idea that judicial settlement of international disputes is the main means of settlement of disputes. I explained to him that, well, if you take a look at Article 33, there's really no hierarchy specified among the different means of disputes settlement. You have negotiation and mediation, inquiry, disputes, judicial settlement, and other means. And then I thought, if you go to Article 36, that means Article 33 means have not been able to do their job, right? That's why you need to go to Article 36. To this extent, then it may be, Article 36 may serve as some kind of residual means, right? Anyway, I told him that, well, if you take a look at one of the most important cases in the PCIJ, the court also said that the judicial settlement of international disputes with a view to which the court has been established is simply an alternative to the direct and friendly settlement of such disputes between the parties. As consequently, it is for the court to facilitate, so far as is compatible with statutes, such direct and friendly settlement by the parties. Only at that point, my friend decided to rest his case. So I hope you will have rested your case today that judicial settlement dispute is not really the main means. Okay. Now, as we move along, you will hear from me that mediation is an aid and adjunct to the direct and friendly settlement dispute or negotiation. Okay? And when we combine all this, we will have the truth that mediation is an aid or adjunct to the main means of settlement dispute, while adjudication, including arbitration, is only an exception or alternative to the main means of dispute settlement. I can see that my time is running out fast, so I will move faster, okay? Now let me give you something about what I consider to be the beauty of mediation. First of all, we'll have the need for mediation. We will see that many disputes are not settled or have not been settled by direct negotiation alone. You can see the dispute between Israel and Palestine. And a number of disputes actually are not settled by adjudication, including arbitration. You can see this between Israel and Palestine. Some of the cases are going on at the ICJ. Or we can say that adjudication or arbitration cannot finish the job. You can see that in the dispute between Cambodia and Thailand about the temple, and also the Beagle Channel case between Chile and Argentina. And you can see mediation can do something really great as the warming up the re-establishment of relationship between Iran and Saudi Arabia and the Palestinian internal conciliation. And those people came to meet in Beijing. Right? Anyway, we can also see some wisdom from mediation. Usually we can see that a third-party mediator participating in the process, this person can provide very good guidance to settle disputes that the parties themselves may not have thought about. And also a third-party mediator's presence alone actually may lead to the parties themselves reassessing or more realistically reassessing their own claims. Usually, claims cannot be settled because they are really exaggerated by each side. The presence of a third-party mediator, particularly with some kind of proceedings going on, the parties are forced to reassess their own claims in a more realistic, more practical way, and probably more rational way. And this helps to settle disputes. In mediation, a third-party mediator can also help along the way, unlike in adjudication or arbitration, because usually in adjudication or arbitration, when the third party speaks, his or her words or their words are final. Right? But in mediation, the mediator can help along the way. In mediation, the parties can base their decisions on a broader range of factors than in adjudication or in arbitration. Because in adjudication arbitration, law is the basis for decision. But in mediation, many other factors can be brought to bear on the settlement of the dispute. And then there will be a broader range of other benefits which have been taught about by Mr. Nino, and also later on by our friend Gaston also. Now, let's take a sneak review on some of the provisions of the IOMEC Convention. Okay? The convention has established a very unique organization, the only intergovernmental dispute settlement organization devoted solely to the use of mediation to settlement of disputes. And this convention takes a very broad view of mediation, as I mentioned earlier. The definition for mediation is that mediation means a process, whether referred to by the term mediation, conciliation, or other similar expressions, whereby the parties attempt to reach a mutually acceptable and amicable settlement of their dispute on a voluntary basis with the assistance of third person or persons, the mediator, who may facilitate a solution between the parties to the dispute and lack the power to impose it on the parties. Now, the convention affirms all the fundamental principles on dispute settlement: party consent and party autonomy, respect for sovereignty and territorial integrity, equality, non-interference in the internal affairs of states, and commitment to international rule of law, ensuring party autonomy and free choice of means in dispute settlement, good faith and spirit of cooperation, and ensuring the partial, neutral, and equitable environment that foster settlement disputes. Now, the convention grants a very broad scope of cases of jurisdiction to the organization and the process. In Article 24, you will see that the organization shall provide mediation services for the settlement of disputes submitted by the parties by mutual consent expressed before or after the dispute arises. In Article 26, we have something quite interesting. The Convention provides for exception to protect third-party interests. In case of disputes submitted by states involving a third state, the organization shall not provide mediation services with respect to such disputes unless prior consent is given by the third state concerned. Now, in Article 29, the Convention provides for exceptions to respect the sensitivities of some states. States can declare that they will not submit any case about certain categories of issues to the organization. Now, finally, which is, I think, most important, the Convention demands very high quality of services from the IOMED, including the mediators and the staff. Right? This sneak review, I think, will give you already a good idea of what this organization is going to be like. And now let's take a look at the mediation rules, which will help the organization to stand on very firm ground and to provide the most effective services. The state-to-state mediation rules, which I help draft, leading the expert group, we held several meetings. We check many rules, check many what we consider to be precedent, and we consider many issues. We decided that these few points are important and they are implemented in the rules. First, the rules are intended to implement the relevant provision, the IOMEC Convention, of course, the Convention's enabling act for the rules. And secondly, the rules respect the principles of voluntariness, party autonomy, and flexibility, offering states a high degree of procedural control and predictability. The general rule is that the parties are in full control. Parties may modify the rules and do many things. Okay? If the parties decide a more rigorous approach to mediation, decide to use a more rigorous approach, a set of optional rules are available for them to use. The rules are formulated in a way that they should be sufficiently clear, concise, and user-friendly for direct use by states. They can just use them without further ado. Okay? And the last factor is that the rules are supposed to be compatible with the institutional character of the IOMED, including the role of the Secretary General and the Secretariat in supporting the mediation process. I suppose we don't need to go through the details here in the, at this setting, and there's not enough time for me, right? I'm running out of time. I just would like to mention that the rules contain very elaborate procedures for institution of proceedings, the initiation of proceedings, and the protection of third-party interests, appointment of mediators, and in addition to the rules on the conduct of the proceeding, the detail, working out of the proceedings. I also would like to mention that as far as the treatment of third-party interests, is concerned, the rules provide for a very elaborate kind of procedure to deal with that issue. We know that if any involvement of the interests of third party serves as an impediment to the proceedings, then there will be very few proceedings that because any international dispute is highly likely to involve some interests of a third party. After much soul searching, the formulators of the rules decided to follow the jurisprudence of the International Court of Justice. For the purposes of these rules, a third state is deemed to be involved when the interests of that state constitute the very subject matter of the dispute, or a decision or determination of those interests is a prerequisite for the resolution of the dispute submitted to mediation, which is not easy to satisfy. It's a high threshold. Now, I'm done. I can see that all signs are that Hong Kong is ready to take its place as the mediation capital of the world. Things just need to happen. And I wish Hong Kong good luck. Thank you very much.
Thank you, Professor Yi, for his very valuable insights into several aspects of mediation. Professor Yi shared with us the narrow and broad concepts of mediation, the role of mediation in the international dispute context, as well as the wisdom from mediation, and very good summary of the IOMED Convention and the state-to-state mediation. We are very grateful for Professor Yi's sharings. And moving on, if I may, to our second guest, our second expert for the purpose of today, Mr. Gaston Canvic-Durali, Director of Legislation, Minister of Justice Cameron, who is also a co-facilitator of the expert group on IOMED rules on international commercial and international investment mediation. So without further ado, if I may hand over the floor to you, and grateful for your sharing. Thank you.
Ladies and gentlemen, distinguished guests, first of all, I wish to thank the Honorable Paul Lam Tin Kwok, Secretary for Justice of the Government of Hong Kong Special Administrative Region, People's Republic of China, for inviting me to this Hong Kong Legal Week 2025. At the same time, I wish to extend my condolences to the region of Hong Kong for this dreadful fire which has brought grief to many families here. This done, I wish to recall that the International Organization for Mediation, which acronym is IOMED, was established by a convention signed in Hong Kong on 30 May 2025. The purposes and objectives of the IOMED shall be to promote and facilitate peaceful settlement of international disputes and to develop friendly relations and cooperation among states through mediation. The disputes mentioned here, on the one hand, are those arising between states, just presented by Professor Yi, and on the other hand, international commercial dispute between private parties and dispute between a state and a national of another state, that is, in reality, international investment dispute. I understand that I am expected to present the IOMED mediation rules for the settlement of international commercial and international investment disputes. Neither the IOMED Convention nor the IOMED rules for the settlement of this dispute do not define international commercial and international investment disputes. Likewise, commerce and investment are not defined in this instrument, but we know that a commercial business is an economic activity that involves buying, selling, or exchanging goods, services, or property for immediate profit, whereas investment is the act of allocating money or resources into assets like stock, lands, or real estate with the expectation of generating income or profit over time. Concerning the international nature of investment and commerce, the IOMED Convention and the IOMED rules of mediation are also silent on the definition of the internationality of those activities Therefore, we shall adopt here the definition contained in the Ancestral Model Law on International Commercial Mediation, which is one of the sources of inspiration of the ROAP mediation rules. According to the Ancestral Model Law, a mediation is international if, and I quote, the parties to an agreement to mediate have, at the time of the conclusion of that agreement, their places of business in different states, or the state in which the parties have their places of business is different from either the state in which a substantial part of the obligations of the commercial relationship is to be performed, or the state with which the subject matter of dispute is most closely connected, end of quotation. This definition is acceptable here, especially since it corresponds to the commerce and investment targeted by the ROAP Convention, which formally excludes dispute arising out of transactions engaged in by one of the private parties for personal, family, or household purposes. All these clarifications made, it seems to me wise to present, at least in broad outline, the ROAP mediation rules before indicating to what extent the said rules are likely to promote peace, contribute to building harmonious international relations, and promote the use of mediation. Now, the first part of my statement, the ROAP mediation rules. These rules define mediation as being a process, whether referred to by the term mediation, conciliation, or other similar expressions, whereby the parties attempt to reach a mutually acceptable and amicable settlement of their dispute on a voluntary basis with the assistance of a third person, the mediator, who may facilitate a solution between the parties to the dispute and lack the power to impose it upon the parties. This definition is inspired from the one contained in the Ancestral Model Law on International Commercial Mediation. And according to the ROAP mediation rules, the Secretary General of the ROAP is in charge to administer mediations relating to international commercial dispute and international investment dispute submitted to the ROAP by the parties. Concerning the request for mediation, a distinction has to be made between the existence and non-existence between the parties of a prior agreement to solve their dispute through the ROAP mediation rules. Indeed, when the parties have an agreement to mediate, any party wishing to institute a mediation shall file a request for mediation with the Secretary General by using a request form annexed to the rules. The request shall be either in Arabic, Chinese, English, French, Russian, Spanish, or any other language with the approval of the Secretary General. The said request could also be filled electronically unless the Secretary General directs otherwise, and must be filled together with the payment of filing fee in accordance with the ROAP scale of fees. These requirements show that, like arbitration, mediation is a paid service. If the Secretary General deems the request of mediation within the scope of Article 27 and 28 of the ROAP Convention, he or she, but we'll say she because it's Teresa, she shall invite the other party or parties to consider the request and reply in writing within 30 days or such extended period as may be determined by the Secretary General. The other party shall fill his response in conformity with a response form also annexed to the rules. In the case where the parties have no prior agreement in writing to mediate, any party or parties wishing to institute a mediation shall file an offer to mediate with the Secretary General in accordance with the offer from annexed to the rules. If this offer to mediate is within the scope of Article 27 and 28 of the Convention, the Secretary General shall invite the other party or parties to consider the offer and reply in writing within 30 days or such extended period as may be determined by the Secretary General. If the other party does not comply with the requirement of the Secretary General, the mediation will not take place. On the other hand, if the other party or parties fill an acceptance form to accept the offer to mediate, the Secretary General shall register the case for mediation upon receipt of the administrative fees. Whatever be the case, after the registration by the Secretary General of the acceptance to mediate, the proceedings will move forward with the constitution of the Mediation Commission, which is made up of one or more mediators unless the parties otherwise agree. It is specified that if the parties cannot reach an agreement on the number of mediators within 14 days, no, it's not only 5 minutes, it's more than that. I'm controlling. It is specified that if the parties cannot reach an agreement on the number of mediators within 40 days after the registration of the case, any party may apply to the Secretary General acting as the appointing authority for a decision on such numbers. If no party applies to the Secretary General 40 days after the registration of the case, the Secretary General may, in consultation with the parties, decide the numbers of mediators to be appointed. The rules specify how the parties shall appoint one or more mediators. And once the Mediation Commission is in place, the parties shall cooperate with it and with the Secretary General in good faith. They shall also adhere to the IOMED mediation principles. For its part, the Mediation Commission must adhere to the IOMED mediation principles, according to which the mediation conducted under the IOMED rules adhere to the principles of voluntariness, impartiality, independence, good faith, efficiency, time and cost effectiveness. Otherwise said, in the conduct of the Mediation Commission shall seek to maintain fair treatment of the parties, provide each party with a reasonable opportunity to participate in the mediation proceedings, and promote the settlement of the issues in dispute in accordance with the Code of Conduct for Mediation. Generally speaking, you are disturbing me. Generally speaking, it's expected from the mediator that he remains neutral, independent, and impartial. Moreover, he must be respectful of the will of the parties in the conduct of the proceedings. The mediator member of the Mediation Commission may be replaced for resignation or for other reasons. They shall conduct the proceeding in the form of physical meetings at the headquarters of the IOMED, that is here in Hong Kong, or by way of virtual meetings through secured online platform designated by the IOMED. As for the duration of the mediation proceeding, it should be completed within 6 months from the date of institution of the Mediation Commission or such extended period as agreed by the party, the Mediation Commission and the Secretary General. The extended period shall not in total exceed 6 months unless exceptional circumstances exist in the views of the Mediation Commission. Rule 19 of the ROAP mediation rules indicate how the mediation proceedings shall be terminated. The mediation settlement agreement as the consequence of the proceedings might include documents in electronic form signed by the parties using electronic signature and exchange through electronic communication. According to the rule, by signing the mediated settlement agreement, the parties agree that it can be used as evidence that it results from mediation and that it can be relied upon for seeking relief under applicable terms in a court of law. A flexibility note rule concludes the ROAP mediation rules and states that no party shall be precluded from attempting mediation on the same subject after that has previously been mediated, whether or not such mediation is administered by the ROAP. Thus presented, the ROAP mediation rules, which are complemented by a code of conduct for the ROAP mediators and an explanatory note, appear to be an appropriate instrument to promote the use of mediation. Now, in the second part of my statement, I will indicate how the mediation rules is an instrument for the promotion of peace through mediation. The analysis of the ROAP mediation rules discloses a flexible and universal instrument. Its universality comes from its sources of inspirations. Indeed, as already indicated, the ROAP mediation rules are mainly inspired from the UNCITRAL model law on international commercial mediation. In this regard, it must be recalled that the UNCITRAL model or binding texts are generally widely accepted worldwide because they are elaborated by the peoples from the different legal and economical systems in force in the world. Therefore, the ROAP mediation rules will undoubtedly be universally accepted and applied. Then the ROAP mediation rules are also inspired from the other modern instruments like the ICSID rules on mediation, the PCA arbitration rules, and the ICC mediation rules. Indeed, both the ROAP mediation rules and the ICC mediation rules state that the mediator shall respect the parties' preferences and decisions to the fullest extent possible in the conduct of the mediation proceedings. Likewise, the offer to mediate from a party not having prior agreement in writing with the other party to that effect is present both in the ROAP rules and in the ICC rules of mediation. Thus, based on globally recognized instruments and being likely to be applied in either Arabic, Chinese, English, French, Russian, Spanish, or any other language with the approval of the Secretary General, the ROAP mediation rules are modern and flexible rules that will undoubtedly help promoting peace in the world for the settlement of international commercial and international investment disputes through mediation. I thank you for your kind attention.
Thank you very much. Thank you for the sharing by Dr. Deshwani. Because of the fact that we're running out of time, perhaps if I may suggest we start the Q&A session immediately. I have several questions here. Perhaps if I may pick the first one and see what the views of our two guests are. The first question is that In Chapter 8 of the IOMED Convention, references are made to the concept of capacity building initiatives. And obviously, one of the intention behind the convention is to assist and to facilitate capacity building. The question is, what can we do and what should we do in pursuit of such capacity building under the convention? Perhaps Professor Yi, if I may ask you to share your view first.
Okay, just quickly, I think that's not a question for an expert, helping to formulate the rules. It's more about management, more about how to promote the whole organization. But I can tell you that there's something very interesting in the organizational structure. There's a deputy secretary general who will be responsible just for that. Maybe you can direct your question to that person later on. Thank you.
Thank you. Dr. Deshwande?
Yes, I confirm what Professor Yi has just said, but I would add that this issue was raised last October when we were here for the effective commencement of the ROAP functions. And the general idea from the contracting state is that this point is a major point and that the state must finance this activity because capacity building to promote mediation is something very important. So it's up to the state with the assistance of the Secretary General to look for financing in order to implement this activity.
I think one way to look at the question, if I may just share my view, is that I think the culture and the development and the progress of mediation in different states who are signatories to the convention vary. And therefore, it would be at least desirable to enhance and consolidate the progress and development of the mediation culture, the mediation techniques, and matters related thereto, so as to, for those who are very developed or more developed, to make it more advanced, for those perhaps relatively less developed, to assist them to reach yet an even better level. That would be at least one of the way, of course not the conclusive way. And I'm sure to, in a way, harp on Professor Yi's answer, I'm sure the Institute would be more than willing to listen to the views of the signatories and to have a very constructive dialogue as to what can be done and what would be hoped to be done so as to, in a way, develop the initiative across the various signatories. I mean, mediation is a dialogue, and I'm sure the Institute itself would welcome dialogue in different areas. This is the first question. The second question is directed to you, Professor Yi, because you mentioned about perhaps a more vigorous approach to be adopted in mediation. The question posted is twofold. First, you are invited to elaborate and explain more, perhaps by one or two examples, as to what exactly can be done in relation to this vigorous approach. The second question in this area is, are there any boundaries to this vigorous approach?
The more rigorous approach is usually something like this. Okay, so when the parties and the mediators together trying to settle the dispute, the mediator's role can be, more can be calmer or more active. The idea is that we want the mediator to do as much as possible, right, to help settle the dispute. But then, the parties may not necessarily want to solve all the disputes all at once. Huh? They may want to take more time. There may be other considerations. Huh? Usually, the mediators, makes proposals and all that. The proposals can be more detailed or less detailed, and the question has to do with whether the parties are supposed to respond to those proposals. And sometimes parties are afraid that some kind of report, some kind of proposals may be in writing, right? But we can, usually in the normal nature of things, it would be better to have those things in writing and to have the parties respond to those proposals in a conscientious, serious way. But then such proposals, even just, because they exist, they may have, serious impact. So for these kind of reasons, we want to let, the parties decide. So if the parties want to have a, less rigorous approach, then they can do something, simpler. If they want to have a more rigorous approach, they can use the optional rules, or they can tell the mediators to do more. The simple idea is that, some parties, they may not want to have any report at all to be in existence, okay? That's the idea. Thank you.
Thank you. I see that we still have slightly over 3 minutes. If I may pose the last question and invite both guests to give their views very quickly. In short, what should or what can be done to enhance the confidence of the various countries in the world to use the service of IOMED? Dr. Daswani?
I think it's very important to integrate the fact that mediation is a peaceful means to promote, to settle disputes, because it's a kind of diplomatic negotiation and which make the parties very confident and to behave not like if there was in a litigation. It's a flexible means of settlement of dispute in the sense that it's cost effective, as we said, and it is very flexible. You see, people will exchange each other as if they are in a family. Whereas in a litigation, you see, the positions are very tight from one side to another side. So we can focus on the advantages of mediation as a means to settle dispute. And I think with this, we can encourage people and bring them to mediation.
Thank you. Thank you. Professor Yi?
I think mediation as a means of dispute settlement has been here for a long time, but there's not enough, about how mediation has been succeeding. It's interesting, right? There's not too much, that we can find have been, telling us about how the process has been conducted and all that. But in my view, generally, I think the more dialogues between the parties, the better understanding of each other's positions will help to settle disputes. And for this reason, I think it will be conducive to the settlement dispute if the mediators can provide the best kind of explanation of all the issues. I tried to check how the Beagle Channel case succeeded, right? The arbitration decided certain things, and then the Pope came in to help mediate. The mediation lasts over 10 years. And I read that at the end of the day, a most important event was, the ambassador of Argentina to The Hague, who was a very important, very good legal scholar, and another similar one from Chile. They came to The Hague and they, got a very nice dinner and got drunk. And after that, things move in a better solution, direction. I suppose, they must have had very good discussion of each other's positions. So at the end of the day, the lawyers are very, very important because somehow good lawyers can understand each other better than other people understand each other. In my view, in a way, somehow the idea is that usually those who are not, strong on legal grounds, usually at the end of the day, somehow will compromise, I think. Then maybe some other things may be used to compensate for other things. In this way, the idea is that, anyway, get very good lawyers to help, okay? That's the idea.
Thank you. This brings us to the conclusion of this session 1 of this afternoon. Thank you for joining us, and may I again express our utmost gratitude to the 2 experts who join us and share their very invaluable insights. I think we are now going to have a break, and we would like to see you back after the break. So thank you again.
Thank you, gentlemen. And can I please invite all of you to remain in your seat as our photographer is taking a photo right now. So everyone, please coordinate with them. Thank you. Thank you very much, Mr. Yun, Professor Yi, and Dr. Duajni. Did I pronounce that correctly? Is it Duajni? Duajni. Thank you. And thank you, gentlemen. Once again, can I please have all of you take a seat? Thank you for that sharing. I always wish we had more time, but that is it for this segment. Thank you once again for that insightful discussion. Now, it looks like session 1 has concluded right now. Everyone, please scan the QR code that is in the venue to complete the feedback form, as we really appreciate everyone's feedback. Now, for online participants, you may complete it online as well. Now, it is time for a break. Refreshments are available outside the hall. Please do take your valuables with you when you leave. And for online participants, please stay logged in. We will reconvene shortly, and we will come back at 4 p.m. Everyone, please enjoy, and we'll see you shortly. Thank you. Ladies and gentlemen, thank you for joining us for Session 2, Mediation in Action. As we resume our program for this afternoon, can I please gently remind everyone not to clap or not to give any applause during the session so that we can maintain a solemn atmosphere to show some respect to the affected ones by the fire in Taipo last week. So everyone, please make sure you do not clap. This session will discuss the latest development in the government's Deepening Mediation Culture initiative and other mediation schemes in the community for resolving, including financial disputes, building management disputes, and neighborhood disputes, etc. Now today, they demonstrate Hong Kong's mediate first approach to resolving disputes and providing accessible dispute resolution. Please note there will be a Q&A at the end of the discussion, and on-site participants can scan the on-site QR code to submit your questions. And whereas for our online participants, please do submit your questions in the chat box directly. Now our moderator is ready on the stage. Now I will pass the floor to our moderator of this session. He is Dr. Christopher To, Chairperson of Hong Kong Mediation Council. Over to you.
Thank you very much. Good afternoon, ladies and gentlemen. Could I have Leona Zhang, Principal Government Counsel, Legal Enhancement and Development Office of the Department of Justice, Hong Kong SAR Government, to come onto the stage to do the presentation, if she may?
Good afternoon, ladies and gentlemen. Being here today in a room filled with experienced lawyers and mediators, I do not need to talk about the benefits of mediation. Instead, my focus today is to share with you the latest work of the government in deepening the mediation culture, how we're moving from policy to results, and how this connects to your work. 18 years. That's the time it takes for a child to grow into an adult. For mediation in Hong Kong, if we take 2008 as a starting point, that's the year when we set up the working group on mediation, Hong Kong's mediation journey has now reached its 18th year. We began by building institutional structures and guidelines. The working group on mediation and a subsequent mediation task force examined local and overseas experience and mapped out Hong Kong's needs. In 2010, the Hong Kong Mediation Code was promulgated, setting baseline standards for mediator conduct. The Steering Committee on Mediation, established in 2012, strengthened policy coordination and review. Then we built statutory foundations. The Mediation Ordinance came into operation in 2013, providing a clear legal framework for confidentiality, etc., elements which are crucial for the conduct of mediation. The Apology Ordinance followed in 2017, clarifying the legal effect of apologies in legal proceedings and encouraging more open, interest-based human dialogue. In parallel, the judiciary embedded mediation into court procedure. Court rules were amended, and Practice Direction 31 was introduced the possibility of adverse cause consequences for parties unreasonably refusing to mediate. At the same time, the profession organized itself, with Hong Kong MAO established as the principal accreditation body and many other institutions also building their own rules and specialist panels. These developments have given Hong Kong a coherent ecosystem, legal, procedural, and professional, within which mediation can flourish. Today, when we talk about mediation, we are standing on three main pillars. First, the statutory framework, the Mediation and the Apology Ordinance, which I have just mentioned. Second, the court framework, the High Court and District Court rules, together with Practice Direction 31, as well as the various mediation schemes launched by our judiciary, embed mediation as an integral part of legal proceedings. Third is our pool of professionals. Hong Kong MAO sets standards for training, assessment, CPD, and disciplinary matters, while other institutions also contribute in training and maintaining panels of mediators. This professional foundation gives users confidence that they are dealing with trained, accountable mediators. By now, the phrase mediate first is a familiar one in the legal and mediation sectors. And it is not just an aspirational slogan. Today, its achievements can be measured. In 2024 to 2025, across different court mediation schemes, mediation has achieved settlement rates from around half of the cases to over 90%, with the average time to resolution ranging from a few hours up to 140 days in more complex matters. These figures demonstrate three things. First, mediation does not delay cases, rather, it substantially shortens dispute resolution time. Second, mediation performs consistently well across the pilot case types, family, building management, small claims, and beyond. Third, mediation now plays a concrete role in easing court workloads and promoting earlier, more sustainable resolutions. Behind these figures is also the capacity that we have built. As of last month, Hong Kong MAO has around 2,355 general mediators, 346 family mediators, and 67 family mediation supervisors. And on the user side, over 1,000 organizations and individuals have signed the Mediate First pledge, and 52 have received the star logo in recognition for their contributions in the promotion and adoption of mediation in their operations. Statistics alone cannot capture the full picture. In practice, mediation in Hong Kong today touches a wide spectrum of disputes. There are commercial and contractual disputes where business continuity and confidentiality are essential. There are construction disputes where timing, technical complexity, and multi-party relationships make flexible interest-based solutions highly useful. There are family and matrimonial disputes where preserving workable parenting and familial relationships is often more important than winning a case in court. There are personal injuries cases where apology, explanation, and acknowledgement of suffering can be as significant as financial compensation. There are also community and neighborhood disputes where parties have to continue living side by side for years. And more recently, there are sports-related disputes, which I will come to in a moment. For the parties, what really matters is the qualitative benefits of mediation, which I believe everyone in the room is already familiar with. So the key points on the slide, and I won't repeat them. On this note, I will move on to one of the latest developments in the government's work in deepening the mediation culture, the pilot scheme on community mediation. This was announced in the Chief Executive's policy addresses in 2024 and 2025. The scheme is a collaboration between the DOJ, the Environment and Ecology Bureau, and the Food and Environmental Hygiene Department. Our goal is clear. That is to build a more harmonious community by equipping property management staff with mediation skills. And why is this important? As many of us know, in Hong Kong setting, when residents encounter problems, water seepage, noise from neighbors, disputes over the use of common areas, the first point of contact is very often the property management staff. If these frontline staff have the skills to apply mediation techniques at an early stage, they can diffuse emotions before positions harden. They can prevent relatively small disputes from escalating into major conflicts. They can reduce the burden on public resources by reducing complaints in court proceedings. And they can help cultivate a culture of mutual respect and harmony in the residential estate. Since the launch in June 2025, the scheme has completed 5 training sections focusing on these types of typical scenarios. Feedback has been very positive. Participants report that through lectures by experienced mediators, role plays, and experience sharing amongst the property managers, they not only understand what mediation is, but they feel more confident in using mediation techniques in their day-to-day operations. Another key step in moving from policy to result is the mediation clause policy. This was announced in the 2023 and 2024 policy addresses. And the actual policy statement was issued in November last year. The message is clear and simple. The HKSAR government, as a staunch supporter of the Mediate First culture, will, as a matter of general policy, include a mediation clause in all government contracts going forward. The standard mediation clause is also clear and simple. It is on the slide. It basically says, the parties shall first refer any disputes arising out of or in connection with the contract to mediation in accordance with the set of mediation rules that is agreed on. If the dispute is not settled by mediation, a party may then commence court proceedings or arbitration as appropriate. The significance is threefold. First, at the institutional level, it writes mediation before litigation or arbitration into contractual frameworks. Mediation would be no longer an option, but a contractual obligation. Second, at the market level, it provides a template and a signal. By taking the lead, the government invites private contracting parties to consider including similar clauses in their own contracts. Third, at the practical level, it prompts parties and advisors to think about mediation at an early stage, which mediation rules to adopt, how mediators might be selected, and how mediation will be integrated into the dispute resolution roadmap of the deal that they are making. And of course, a clause alone is not enough. The challenge, which many of you are directly involving in addressing, is to ensure that parties approach mediation in good faith, not as a mere procedure to go through. To ensure that the lawyers and mediators help to structure so that it is efficient and meaningful for the parties, and also to ensure that the professional standards and ethics are maintained so that users continue to trust the process. A further area of innovation is the pilot scheme on dispute resolution, sports dispute resolution. With the rapid growth of the sports industry in Hong Kong, disputes over athlete selection, sponsorships, contracts, and governance, etc., have become more frequent and complex. The 2024 and 2025 policy addresses therefore propose establishing a dedicated sports dispute resolution system for Hong Kong. Let me give you a report of what my department has been doing. So, as mentioned, in October 2024, the chief executive announced the policy intention in the policy address. Then in January 2025, the Department of Justice set up an advisory committee on sports dispute resolution to advise the government on the scheme. In the months that followed, DOJ and the advisory committee consulted key stakeholders to understand the industry's needs. Then, on the 30th of June 2025, an open invitation was issued to dispute resolution institutions for proposals on the operation of the scheme. On the 21st of November, upon carefully considering the proposals received, ALCO and EBRAM were selected as the administering body and technology provider of the scheme respectively. The scheme will be formally launched by the end of 2025, and it will last for a period of 2 years until the end of 2027. The scheme has several distinctive features. First, it is a dedicated specialized scheme for sports dispute. Second, it adopts a mediate first, arbitrate next approach. Third, there is law tech support using an online platform for the filing of documents and virtual hearings, enabling participation across locations. That is particularly useful for athletes who may be training or competing overseas. And fourth, there is a government subsidy for eligible non-commercial sports disputes to enhance accessibility. So when we put these strands together, it is clear that Hong Kong, as a capital of mediation, has gone a long way since the establishment of the Working Group on Mediation 18 years ago. Today's foundations include a robust legal system that supports mediation, consistent policy support from the judiciary and the government, a deep and diverse pool of mediators, growing public awareness on mediation, and with a unique bilingual common law system, Hong Kong's role as a bridge for cross-border and international disputes, and with our substantial body of practical experience and success stories in local and international recognition. And for tomorrow, we hope to see that mediation will become the natural first instinct whenever disputes arise. And we hope to see that more sector-specific expertise in emerging fields such as sports and community disputes can continue to develop. And we also hope to further enhance the accessibility and credibility of mediation. An eminent overseas counsel has once given a talk to the DOJ on mediation, and he concluded with this: mediation is the future. This has deeply resonated with me and also my colleagues. And if mediation is the future, that future lies in the hands of everyone in this room. Together, we can ensure that Mediate First continues to be not just a slogan, but a lived reality. Thank you.
Thank you, Ms. Zhang. The next speaker, can we have Mr. T.Y. Lee? Mr. T.Y. Lee is a barrister at law and is also representing the Financial Dispute Resolution Center. Mr. Lee, please.
Good afternoon, ladies and gentlemen. Thank you for the Department of Justice inviting the Financial Dispute Resolution Center to present to you Building Trust and Resolving Financial Disputes in Hong Kong. I will cover those areas this afternoon. First of all, the background. Hong Kong, as you all know, is an international financial center, as shown in the rankings of Hong Kong in high positions in a variety of international indicators as shown on the screen. Under this context, because of the increasing financial investment and also financial transactions happening in Hong Kong, there are bound to be more financial disputes arising. So we have to find a way to resolve those financial disputes. In contrast to traditional litigation, which can be costly, time-consuming, and adversarial in nature, which in the long term may also cause damage to the enduring business relationship. We have now to consider the Alternative Dispute Resolution, ADR, instead. Mediation can offer a cooperative, confidential, and effective alternative. It will also preserve trust while resolving dispute quickly. Arbitration is also an option, which is a private and confidential process, which can provide parties with a relatively fast, final, and binding resolution of a dispute. As shown in the 2025 Queen Mary University of London survey on international arbitration, Hong Kong features in the top 3 most preserved seats for arbitration globally. An ADR can be conducted in Hong Kong effectively because of the following reasons, which some of these factors have been covered in Leona's speech. Firstly, the modern and sophisticated legislative framework. Leona mentioned the mediation ordinance and also the arbitration ordinance, and last but not the least, the apology ordinance, which forms a comprehensive legislative framework for ADR right here in Hong Kong. And also we get a pool of world-class, multilingual, legal and industrial professionals for us to use. And for the parties, we have a free choice of legal representation, the choice of mediator, as well as arbitrators. Now, turning to the background and the FDIC services, we have to mention the Lehman Brothers crisis back in 2008. At that time, there are 48,000 Hong Kong investors who held structured financial products from Lehman Brothers. The total amount being more than 20 billion Hong Kong dollars. And at that time, more than 30,000 complaints were lodged against alleged mis-selling by financial institutions. So Hong Kong has to find a way to resolve such large amount of disputes. At that time, mediation or arbitration was proposed as a means to resolve those disputes between investors and banks. And the government conducted a public consultation on a proposal back in 2010. And as a conclusion of the result, the Financial Dispute Resolution Center, FDRC, was established with SEEK funding from the Hong Kong SL government, the Hong Kong Monetary Authority, Hong Kong MA, as well as the Securities and Futures Commission, SFC. And FDRC commenced its operation in June 2012. Our mission is to provide independent and impartial mediation and arbitration services, with the emphasis on mediation first, arbitration next approach. Our vision is to be the leading provider of financial dispute processes to address differences in financial interests. And we also aim to support Hong Kong's status as an international financial center. The FDRC is also in alignment with the national plan to establish Hong Kong as an Asian Pacific region legal and dispute resolution services center. And it also complements the establishment of IOMED here in Hong Kong to resolve disputes between states. Our guiding principles are 5 in number. It looks like the Olympic logo. And apart from the independence and impartiality, I must emphasize the importance of accessibility in terms of providing a user-friendly and easy to understand procedures for the consumers to follow. And also, FDRC provide cost-effective and time-saving procedures for the customers. Last but not the least, we adhere to the principle of transparency, so far as we respect the confidentiality of parties in the proceedings. Going into greater detail on our scheme, as I emphasized throughout, we adopt the mediation first and arbitration next approach as an alternative to conventional civil litigation. All the financial institutions or financial services provider in Hong Kong are actually members of the FDRS, members of our scheme, insofar as they are authorized by the Hong Kong MA or holding a license issued by the SFC. As in August 2025, there are over 3,600 financial institutions which are members of our scheme. The eligible claimants are individuals, sole proprietors, and small enterprise who are having or had a customer relationship with a financial institution or who has been provided with a financial services. Now, to give you a better idea of what sort of cases that we are dealing with, I give you 2 examples of our real cases that we handle. The customer in case 1 bought an education insurance plan to pay for his son's university tuition fees. When after 15 years, his son was admitted to the university, and the plan also matured, it was found that the amount he could get from a plan was 100,000 less than the total premium the customer had paid over the past decades. And this was caused actually by a partial withdrawal by the customer himself because he knowingly or unknowingly about the consequences of his withdrawal. Case number 2, customers found that the interest rate for his personal loan account was much higher than agreed. And customer refused to pay the monthly installment. In response, the bank suspended the supplementary credit card issued to the customer's son without any notification. His son could not use it in an emergency situation. So if you are the customers in those situations, how can you seek to resolve those financial disputes? Let me walk through with you what those cases will be handled, or how those cases will be handled by the FDRS procedure. Broadly speaking, there are application, vetting, mediation, and arbitration stages of FDRS. And for the vetting procedure, we are here strictly to the intake criteria set down in the terms of reference. And the case officer will consider it carefully whether to accept or reject the application. There are basically 2 types of eligible disputes handled by the FDRC. First one is the standard one, which carries the features of falling within the 24 months limitation period, as well as falling within the amount or limit of 1 million Hong Kong dollars. And legal representatives are allowed in mediation, and one bear one's own costs. It follows the mediation first and arbitration next approach, and the customers can simply apply directly to the FDRC. In contrast, for the extended disputes, the key difference is it requires joint consent, both from the customers and the financial institutions, for submission to the FDRC. And in that case, there will be no time limit and no maximum amount claimable under the scheme. And in contrast, legal representatives will be allowed it, and there will be cost implication in arbitration proceedings. And there are 3 options for the parties to agree to: mediation first, arbitration next, or mediation only, or arbitration only options. The mediation process follows the typical one of pre-mediation meeting, appointment of mediators, as well as a mediation meeting of 4 hours. Then there will be arbitration proceedings if the parties are not able to settle and the customers is willing to proceed to arbitration. And usually we conduct the arbitration proceedings by documents-only proceedings. So it follows the usual exchange of documents, appointment of arbitrators, as well as the rendering of arbitral awards. Now back to the 2 cases that I just mentioned. The first case, the bank offered a small amount of money to cover part of his son's tuition fees, and the customer was happy that he could pay his son's tuition fee. So they are settled after the FDRC mediation. For the second case on personal loans, there are agreements on rearrangement of repayment schedules for personal loan, as well as how to deal with the credit card services. So those are concrete cases that we handle, and that's how we help the parties to communicate, to explore options, and finally to settle their differences. It will also be relevant to those who have the mediation and arbitration experience here in the audience to consider joining the FDRC as our mediator and arbitrator. What we require is he or she must be already on a panel or list of one of the recognized organizations and fulfill our training requirements of 12 hours covering those topics. The third requirement is experience. He or she must have relevant experience in mediation and arbitration on relevant financial products, or alternatively, experience on commercial contract disputes. I would like to conclude that the FDRC dispute resolution procedure facilitates communication between the customers and the financial institutions, could achieve win-win solutions for both parties, as well as maintains enduring business relationship between the parties. Thank you very much.
No need. Thank you, Mr. Lee. Now, our next speaker is Ms. Sandy Lee. She's Assistant Director of Home Affairs Department.
Chris, Liana, TY, ladies and gentlemen, good afternoon. My name is Sandy. I work in the Home Affairs Department. My team and I are responsible for overseeing the implementation of Building Management Ordinance. We also provide a wide range of support service to property owners and stakeholders across the city. In our daily work, we see firsthand that harmony is essential to community living. However, we also recognize a fundamental truth. The property we live in is more than just a place we live in. It is usually, actually, for most of the people in Hong Kong, the most important financial asset we ever have. So it explains why disputes in this area can become so intense. When you feel that your primary asset is at risk or your home environment is threatened, emotions run high. That is why we believe that mediation is more than just an alternative option. It is one of the key tools we have to protect our asset and restore harmony to community. I'm here today to share with you what we have done to make Mediate First policy a reality. As we will see, building management is a unique and challenging environment. It requires a unique set of solutions. So what is the specific problem that we are solving? The challenge we have is a combination of scale, complexity, and human nature. Hong Kong is one of the most vertical cities in the world. We have nearly 40,000 buildings operating with multiple owners. The Building Management Ordinance provides the legal framework for this coexistence. It sets the rules, but as we all know, a set of rules cannot by itself prevent disputes. In such a dense urban environment, disagreements are inevitable. When owners' corporation, individual owners, tenants, property management companies all have different views on day-to-day matters, conflicts will arise. And they are not minor issues. They are complex. Our data consistently show that the same main hotspots for disputes as shown on the slides. For example, disagreements over building maintenance and repairs often involve technical details that are very complex and they involve a large sum of money. For example, operation of owner corporation itself often have a lot of conflicts, and such conflicts can paralyze the decision-making of an entire building. But these disputes are also emotional because they pit neighbors against neighbors. These are people you see every day in the lift. You share the same common areas. The personal toll is significant. And finally, they are costly. The alternative to resolution is often a long, stressful battle at the Lands Tribunal. So what we do in the Home Affairs Department is hoping to provide an off-ramp from this cycle. We hope to offer tools that empower parties to de-escalate conflicts early. It saves time, money, and most importantly, it preserves those critical community relationships. To address these challenges, we recognize that a single approach simply does not work for everyone. A simple misunderstanding requires a different solution than a deep-seated legal deadlock. Therefore, we have developed a comprehensive toolkit. This is a spectrum of services, which each of one is designed for a specific type of problem. The first pillar is our panel of advisors. This is designed for situations where parties are stuck on facts or technical issues. The second pillar is the free mediation service scheme. This is for when trust has broken down and parties need a neutral facilitator to help them talk again. The third pillar is our building management dispute resolution service. It is a judicial-led service for the most entrenched disputes that require a firm evaluative eye. Let me walk you through how each of them work in practice. First is the panel of advisors. Sometimes we find that disputes are not caused by bad faith. They are caused by lack of clarity. Parties are stuck because they cannot agree on basic facts. This is where our panel of advisors adds value. This is not mediation, but a crucial pre-mediation step. It is about fact-finding and expert opinion. Our panel is a multidisciplinary team of professionals. It includes lawyers, surveyors, accountants, and engineers. When a case is referred to us by the district office, we form a small target panel. This usually consists of a convener and 2 members whose expertise is directly related to the nature of the dispute. These experts will study the case materials and then offer neutral advice in a focused interview, which we keep efficient at about 45 minutes. Their job is to clarify rights and responsibilities. This expert advice cuts through the confusion and provides a clear factual basis for everyone to move forward. For example, we have handled cases involving complex maintenance issues. Once an expert surveyor provided an objective assessment of the defect, the argument over who is to be blamed disappeared. The parties had a clear fact to work with, and the dispute was de-escalated immediately. So we say the panel of advisors is an effective tool for factual clarity. But what if the problem is not about facts? What if it is about ineffective communication, personality clashes, or a breakdown in trust? This is where our second pillar comes in, the free mediation service scheme. This is our classic mediation service. We operate it in close partnership with the 2 leading professional bodies, the Hong Kong Mediation Center and the Hong Kong Mediation Council. The process is very structured to ensure fairness. It begins with an intake interview to explain the principles of mediation. Then, our accredited professional mediator will hold preparatory meetings with each side separately to understand their specific needs and concerns. Finally, we move to the formal mediation section to seek a mutual solution. The mediators are neutral. They do not take sides, and they do not give legal advice. What they do is to empower the parties to find their own solutions. We provide up to 15 hours of free service. This is broken down logically into a maximum of 3 hours for the intake and 12 hours for the preparatory meeting and formal meetings. If a settlement can be reached, the parties will sign a legally binding agreement, and we aim to complete this process in 3 months. It works. We have seen long-running disputes over management fees settled in under 12 hours. Often, it was simply because the parties had really never sat down in a safe, structured environment to actually listen to one another. And our mediator can facilitate this process when they feel safe, when they feel they can talk to each other. The dispute will go away. And finally, for our most complex and entrenched disputes, we have our third and most intensive service, the Building Management Dispute Resolution Service. The key differentiator here is who provides the service. These cases are steered by retired judges or judicial officers. This is a very deliberate choice. Using a retired judge brings 3 critical elements to the table. It brings extensive judicial experience in building management cases. It brings a sense of gravitas that commands respect. And it also brings a trained evaluative eye. It is different from classic mediation service. It includes a dedicated evaluation meeting. In this section, the retired judge can provide a non-binding opinion or assessment. They help the parties to reality test their case. They ask the tough questions, such as asking the parties to consider the real weaknesses of their argument if the case are indeed to go to court. This service provides up to 22 hours of intensive support. It includes 3 hours for intake, 7 hours for those critical evaluation meetings, and 12 hours for mediation. Again, we aim to finish within 3 months. Let me share with you a practical example of how this worked. So we once had a case involving a shop owner. She got trapped in a malfunctioning lift. In the panic, her staff forced the doors open to rescue her. It damaged the lift. The owner's corporation therefore sent her a big repair bill for the damage. The shop owner, she felt unfair and refused to pay. Because the lift itself had a long history of problems, also her call for help at the time was not answered at all by the management office. Of course, she is unwilling to pay. But both sides felt that they were right. At the evaluation meeting, what happened? The convener, who is a retired judge, skillfully guided the conversation. He helped them bridge the divide between strict liability and practical fairness. In the end, the parties reached a mutual settlement on the repair cost. This is how a stressful confrontation was turned into a workable solution, and they avoided court entirely. So as you can see, the Home Affairs Department's strategy is to provide a structured spectrum of precision tools. We have an advisory panel when you need facts, when you need expert advice. We have classic mediation service when you need to talk to each other in a safe environment, in a guided way. And we also have a judge-led service when you need to break a deadlock. These are neutral, voluntary processes. They empower willing parties to craft their own solutions. By making time gapped at 15 to 22 hours, we provide a predictable and affordable resolution pathway. It stands in stark contrast to the open-ended cost and indefinite timelines of litigation. And of course, the success of any of these tools ultimately depends on the willingness of the parties to participate in good faith. This is our mediate-first approach in action. This is how the Home Affairs Department is actively working to build harmony in our communities, one building at a time. Thank you.
Thank you very much, Ms. Lee. Now, the three speakers have actually given a lot of information to our audience. Now, there's a few questions I want to sort of ask them from the audience. One is regarding the mediation clause policy. I think this is for Ms. Zhang. What early impacts have you observed since its implementation? Were there any hurdles encountered by government departments in incorporating mediation clauses in their contracts? As well as what are the next steps to encourage its wider adoption in the private sector? Ms. Zhang, please.
Thank you for the question. The mediation clause policy took effect on the 6th of February 2025, that is in the beginning of this year. And so far, as we can observe, there is a good general compliance by the government departments and bureaus. And we can also see that there is an increased overall awareness of mediation amongst the government officials. However, a challenge is that because for contracts, it requires two parties. One side is the government, and the other side is a non-government outside party. And we also need the other party's agreement to the mediation clause before it can be written into the contract. So to even further deepen the mediation culture, our next steps would be to further increase public awareness of the benefits of mediation and to increase the public's knowledge of the advantages of including a mediation clause in the contracts. And that way, we can further enhance the effectiveness of the policy. And to do this, my department has been organizing various promotion activities that includes the Mediate First Pledge, which I have mentioned in my presentation earlier. We now have over 1,000 pledgees, and we welcome all organizations and individuals interested to also join the rank. And also there is the Mediation Week, which is organized every 2 years, and the next one will be in May 2026. So I invite all of you to stay tuned and mark your diaries.
Thank you, Ms. Zhang. Thank you for that information. Now, Mr. Lee, there's a question about the Financial Dispute Resolution Center from the audience. The question goes like this. Parties to financial disputes are free to use alternative dispute resolution services other than the Financial Dispute Resolution Center. Why should they choose your organization?
Good question. I think in comparison, we have this added advantage because, as you see, the scheme is established by these terms of reference agreed upon by the government, the Hong Kong MA, and also the SFC. And those financial institutions are regulated by these bodies. So under the terms of reference, both the consumers and the financial institutions may, under some circumstances, require cooperation by the FDRC. Those may include attendance at the pre-mediation session or provide a translator in specified cases and also provide further information. So those who are under the scheme is required to provide cooperation, which you may not be able to find in ordinary mediation if you approach other institutions. So should I also add that in cases where the parties go through the mediation process, we also specify that the parties should join the mediation in good faith and also give full cooperation. Those are set out in the terms of our terms of reference. Thank you.
Thank you, Mr. Lee, for that information. Our next one is for Ms. Lee. The Home Affairs Department has 3 separate services, which you mentioned very clearly, for resolving building and management disputes. Why not just have one single mediation scheme? So what's the difference between the mediation services provided by the Home Affairs Department and other organizations around in Hong Kong?
Thank you. Thank you for your question. It actually gets to the heart of our approach. From our experience, for building management disputes, there's no one-size-fits-all. A single mediation scheme cannot be effective to address all the disputes we see. a simple dispute over facts is quite different from a complex emotional deadlock between an OC and its owners. And what we have developed in the Home Affairs Department is a tailor-made set of mediation services. For example, our panel of advisors, we have expertise from accountants, we have expertise from surveyors, engineers, and of course lawyers. That is because we have seen building management disputes in need of these expertise. So we are crafting a set of very tailor-made tools that our citizens can use when they run into problems in building management. And also, our toolkit is very specialized. We focused on building management cases. And we are talking about building management ordinance, which provides a legal framework for the coexistence of multiple owners. And we have a set of mediation tools to tackle with problems or disputes that can arise in an environment when owners have to work together to have to live in the same place. So it is different from the rest of the cases we may see in other mediation services. Thank you.
Thank you, Ms. Lee. Another question for Ms. Zhang, if I may. I know that you've been working very hard in this area. This question relates to what's the rationale behind the government's policy initiative of strengthening the accreditation and disciplinary systems for the mediation profession?
I believe the question is referring to our initiative in reviewing the mediation regulatory regime. And for this purpose, we have set up a working group for the review late last year. And since then, the working group has reviewed the mediation regulatory regime in Hong Kong, and we have consulted stakeholders. For those who have responded to our consultation, thank you for your comments. And our team has studied carefully the responses to the consultation, and we are now finalizing the recommendations to be put forward. And the key rationale for doing this is that for mediation, trust by the public in the mediation process is key. So by reviewing and making sure that our regulatory regime is moving on with the times, because our market has grown quite a lot since mediation started to develop in Hong Kong. So we have to make sure that our system remains current with the market growth. And by doing this, we can ensure that the public who choose to use mediation will enter the mediation room with the confidence that the mediator who will be assisting them will not only be properly trained, but also will maintain the highest level of professionalism and provide quality service.
Thank you, Ms. Zhang, for that. Now we have Mr. Lee, a question about this, which even I myself might ask as well. So basically, it's what opportunities are available for the legal professionals to participate in the work of the FDLC?
Thank you. I think one of the most direct and relevant way that the legal professionals can participate in our work is to join us as the FDLC mediators or arbitrators. I cover quickly in my presentation the requirements or conditions for those who are interested to join. Let me briefly recap here. Firstly, one will have to be listed as a recognized mediator or arbitrators in one of the arbitration or mediation bodies, such as Hong Kong IC, a law society, or the Bar Association. The second requirement is he or she has to go through a 12 hours training of coursework as well as assessment on two particular areas. One is on the regulatory framework, the FDLC procedures, as well as the sharing of experience by our mediators and arbitrators. The second aspect is to cover the financial products as well as their selling process, so that we have to ensure that those mediators and arbitrators are well equipped with the most updated knowledge to resolve the disputes. And the third requirement is they are required to have the relevant experience on mediation and arbitration in respect of financial products or more generally on commercial disputes between individuals and companies. So those are the 3 basic requirements. For details, you can check on our website for details or contact us if you are really interested. Thank you very much.
Thank you, Mr. Lee. I think this one may be just one last question because this is for Ms. Lee. It relates to the building management dispute resolution services used by retired judges. How does that differ from traditional mediation? It is not just like going to court, is it?
Thank you. That's a fair question. Well, the distinction is crucial. First of all, after all, it is still not like going to court. It is a voluntary and confidential process. The retired judge only brings in their judicial experience at the Lands Tribunal handling building management cases to the process. And he has no power to impose a binding decision on the parties. So it is very different from a court. But it is also not the same as a classic mediation service in the process. In a classic mediation, the mediator is a neutral facilitator to help the parties to talk to each other. They do not give opinions. So here, in the building management dispute resolution service, the convener can hold an evaluation meeting. In this meeting, they use their deep experience to provide a non-binding opinion or assessment so that parties can reality test their case to know the strength and the weaknesses of their case. And without having to go to the court, they can actually sit down and knowing the strength and the weakness of their own case, and they can work out a solution themselves without going to the court at all. I think that's the key difference. Thank you.
Thank you very much. There are many questions, but we can't answer them all because the time is pressing. But on behalf of the organizers, we thank, for example, Ms. Zhang, basically Mr. Lee, and Ms. Lee for their participation in this session. Thank you.
Thank you once again. And can I just have everyone remain in your seats as the photographer will now take a photo. Thank you very much for sharing the government's mediation initiatives of the government and mediation schemes in the community that's regarding to different type of disputes. As always, I wish there's more time. However, we do thank you for that fruitful sharing and discussion. Thank you very much. Everyone, please be seated. Thank you very much. Please be seated. Once again, appreciate all the speakers for sharing their insight on mediation. Now, in session 1 today, we explored the use of mediation in the context of interstate disputes, as well as the commercial conflicts between states and private entities. Then in session 2, our panelists share the government's deepening mediation culture, the initiatives including mediation clause policy and pilot scheme on community mediation, as well as the other mediation schemes that are undertaken by the Home Affairs Department and also the Financial Dispute Resolution Center that has a view to promote the use of mediation in order to resolve the common disputes in the communities that arise by providing accessible dispute resolution. And of course, all of this together, this truly demonstrates the mediate first is in the action that is impacting our daily lives. And of course, we're getting close to the end of our session today, and then we will have another small segment before we wrap up. However, we do appreciate everyone's attendance today, and thank you so much for refraining from clapping our hands. And during this time, I would also strongly encourage everyone today to fill in the questionnaire to actually tell us what you think about our event today, any input, any comments, anything you like about our events, please do reflect to us. Now, ladies and gentlemen, as we approach the end of the afternoon session, can we invite the Honorable Dr. Chen Kok-kwan, SBS JP, Deputy Secretary for Justice, the government of the Hong Kong Special Administrative Region of the People's Republic of China, to come on stage to deliver our closing remarks. Dr. Chen, please.
Distinguished guests, ladies and gentlemen, good afternoon. Allow me to conclude this afternoon's enriching dialogue and meaningful exchanges with a few words. As a true advocate for alternative dispute resolution, the government has been making consistent and focused efforts in enhancing the culture of communication and understanding within society. Since the introduction of the Deepening Mediation Culture initiative in the 2023 policy address, we have stepped up the promotion of mediation and arbitration services, solidifying Hong Kong's position at the forefront of both global and regional dispute resolution. As this season's theme suggests, Hong Kong is well positioned as the capital of mediation. From the two-panel discussion, with the valuable contribution and sharing from our speakers, we covered the role of mediation from both international and local standpoints. From dealing with interstate disputes, commercial conflicts, financial matters, to community frictions, it has been shown that mediation can play a crucial role at national level as well as in various aspects of our daily life. From the global perspective, as a prominent international financial center, Hong Kong provides not only extensive financial services, but also specialized financial-related dispute resolution services. Mediation, in particular, plays a critical role in addressing complex multi-border financial disputes by offering a fair and efficient resolution process, focusing on reaching a solution acceptable to all. This capability reinforces confidence among external investors and businessmen, reassuring them that their interests and property are well protected in Hong Kong. On a local level, disputes are more diverse and seldom carry a clear price tag. Issues that impact our daily lives, such as water seepage, noise complaints from shared walls, or disagreements over communal facilities, can be equally stressful and disruptive. Unlike commercial disputes where a party's relationship is primarily contractual, these community conflicts involve people whose lives are closely intertwined, making amicable resolutions even more critical. In these cases, mediation has proven to be the most effective way to restore harmony. Indeed, conflicts could well escalate and move from one matter to another if they are not peacefully resolved efficiently. Beyond resolving disputes, mediation also builds trust and encourages collaboration, hence fostering a long-term amicable relationship in the neighborhood. By offering mediation skills training to property management staff, we trust we can greatly enhance the effectiveness of early intervention in community disputes. We hope after each amicable dispute resolution, the neighborhoods can continue to treat each other with courtesy and enjoy each other's company in the community. Looking ahead, I would like to share some upcoming developments on local mediation. As mentioned in this year's policy address, the government will continue to strengthen the accreditation and disciplinary systems for the mediation profession. Since the establishment of the working group on mediation regulatory systems in 2024, a systematic review of Hong Kong's regulatory framework for the mediation profession has been conducted, resulting in the formulation of 7 preliminary recommendations. The working group will continue to work on proposing suitable measures for enhancing the sustainable development of the mediation regulatory system. Following the completion of the 15th national game co-hosted by Guangdong, Hong Kong, and Macau, we have witnessed the immense potential for growth in the sports landscape in the region. This provides Hong Kong with the new opportunities for even more collaboration and development. With this growth, it comes the need for a neutral, fair, and efficient dispute resolution mechanism to address any conflicts that may arise in areas of sport and related business. In this regard, the Department of Justice will soon launch the pilot scheme on sports dispute resolution to promote and support the sustainable development of the sports industry in Hong Kong. Lastly, this evening, the mediation lecture will explore an emerging area of dispute resolution, entertainment. Our distinguished lecturer, Professor Song Ki-hong, has come all the way from the Republic of Korea to share his distinctive perspective on this topic. As we conclude today's session, we would like to impress upon all of you to take mediation in action and to create a community grounded in understanding, collaboration, and lasting harmony. Thank you very much.
Thank you, Dr. Zhang. Thank you for the remarks, and please be seated. Ladies and gentlemen, the session of Capital of Mediation has come to a close. On behalf of the Department of Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, I would like to express our most sincere gratitude to all of our speakers and all of our moderators for their insights and their excellent presentations. We would also extend the special thanks to every guest who participated today, both in person and online. And also, please note, please scan the QR code in the venue to complete the feedback form. Online participants, you may complete that online, as all of your feedback are very, very important, and we would highly encourage everyone to please take a minute and fill it back to us. And not only that, for in-person participants who require the continuing professional development, CPD credits, or the advanced legal education, ALE credits, please do present your QR code outside the conference hall to register your departure and to confirm your attendance record. Now, for the headsets, if you were using that, please return the headsets at the service counter that is right outside before leaving. Now, it looks like that's the end of today. Thank you very much for joining us in person and online. We look forward to seeing all of you at the Hong Kong Mediation Lecture this evening. Thank you. And my name is MC Melody Kwan. We look forward to seeing you again tomorrow and on Friday. Goodbye.